Megan Fox.
Yeah, Megan Fox has the story.
Megan Fox.
Megan Fox.
Megan Fox writes at PJ Media.
Eat Tucker.
And that was your last.
Damn it, man. I cried for 2 days.
Megan, thank you very much for that.
So, I can explain the bed thing.
If you don't show up and vote, up your ass. I don't care if you're in the hospital. Crawl to the stake. Crawl there.
It's like Jesus going into the temple. He's like, I got a whip. Get out! Get out!
The lovely and wonderful Megan Fox. Not that one.
Not that one. Not the weird one that drinks blood in his toe thumb.
Megan Fox.
Megan. And honestly, Megan, if you don't like it, I'm sorry.
She's the devil.
Megan.
Megan Fox.
Megan.
Megan.
Megan Fox.
I've been very nice to you, although I could probably maybe not be based on the way you have treated me, but I wouldn't do that.
You've never met a like me. You want to tangle? You want to go? Holy sh!
Too much cussing on this. I guess we didn't bleep it, so we got to turn it off. But it's.
You pissed off the wrong woman.
Oh my God! I have been assaulted, but Megan Fox runs wild on you, brother.
She's the devil. Not for publication.
The story.
I'm Megan.
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 Megan Fox.
Thank
Thank you. Cheers.
Hey guys, good morning. Good morning. We're back. I'm back. God, I thought yesterday was going to kill me. Absolutely kill me. That was the craziest, longest day in the most boring. How do you take a case like the Maya Kowalski case that is full of drama and tragedy and malfeasance and corruption and collusion and government evil? How do you take a case like that and turn it into a sleep aid? I don't know, but these attorneys totally did it. The attorneys on both sides are unbelievably boring AF. And I had to start late today because I can't watch them at real time. Watching them at real time is what I imagine taking a pharmaceutical sleep aid is like. And I can't even believe that they're doing her this disservice. I mean, it would be wonderful if Johns Hopkins attorneys were as boring as they are. We don't care about them. But Maya Kowalski's attorneys need to have some emotion behind what they are doing. Emote, fellas, and stop talking to the jury like this. You should not operate heavy machinery while listening to this trial because you could fall asleep and kill someone. Holy cow. I mean, it is just crazy. All right, I'm dressed for work. I have to go to work today. I'm not going to be doing this entire trial today. This is simply part one. Legal Vice is going to be joining me very shortly. We'll give him a minute to get here. So we're going to start looking at this trial again. If you're new, if you're joining us here for the first time, make sure that you're following me over at meganfox.locals.com. That's where you're going to get all the notifications because, and repeat after me, YouTube is asshole and they won't give you your notifications if you subscribe to this channel, but that doesn't mean you shouldn't subscribe hit that subscribe button, hit that like button. I am trying to get to 20,000 subscribers, which I had been very close to right before YouTube demonetized my channel, and it's dropped off since then. And I would really like to hit that milestone, even if they aren't going to pay me, because I worked damn hard for this channel. And I think I deserve the subscribers that I worked for. Damn it. American Dreamer says, hair tamed. Yes, yesterday I made the mistake of brushing my hair. And it was like literally out. It was off camera. It was so big. And so I had to, when I go to work, I slick my hair back like this because, food service, you don't want to have your hair, especially hair like mine everywhere. So I always, it's wet out of the shower with some gel. I had to gel it down and slick it back. It does feel nice and cool, though. I like it off my neck. All right. Hold on, I'm sending a text. All right. Okay. All right, what are we doing? I have to get over to the, oh, I know what I was going to tell you. Hold on. I'm still recovering from that terrible sinus infection that I had, and I still have a cough. Can you believe this? This cough it's been more than 10 days. I mean, it's just ridiculous. Yeah, for a $200 million trial, you would think that Maya's attorneys would be more enthusiastic. The payout is going to be huge, fellas. Why can't you put some emotion behind what you're saying? Like, you've got a great case, I think. I mean, I know it's an uphill battle. It always is with hospital malpractice, or they're claiming false imprisonment. If you're just joining us, I'm going to turn the ticker on the bottom of the screen. It gives you a short recap of what's happening in this trial, and then also information on where you can send a super chat, because YouTube doesn't want me to make any money on my opinions and thoughts and on my channel, even though I've worked really hard for 10 years to build it. So they took away my ability to take your super chats, but that doesn't mean that you can't send them on Cash App or Venmo, and it's going across the bottom of the screen. Please do send tips and comments that way, and I will be able to read them out on the program, just like a super chat, but it will not, Google doesn't get any of it, which is great. All right, we are also on Rumble. Hello, Rumble folks. We are broadcasting live on Rumble, broadcasting live on Locals, meganfox.locals.com. Make sure that you are following me there. You don't have to pay money to follow me there for free. And you will turn on your notifications. You'll get all the notifications of where I am and what I'm doing. But if you do want to subscribe on Locals, I am doing some hilarious and fun content over there. We're doing it's kind of like home ec over there, cleaning, cooking, and tales from the restaurant where I work as a waitress, and where I've been healing my neck and doing my physical therapy, getting my 10 to 16,000 steps a day. It's amazing. So much fun. I'm loving every minute of it, learning how to make new drinks. I just put up a drink recipe last night on Locals. I made a little video, and in fact, I should share it with you because this is my new favorite drink, you guys. It's so good. Now, my favorite summer drink this summer has been the whiskey sour, the classic whiskey sour with a farm fresh egg white and lemon juice and whiskey and simple syrup. It's so good. Well, there's a fall twist. I found a recipe for a fall twist on my favorite drink, and I made a video of it last night and posted it on Locals. So if you are not on Locals, this is the kind of stuff that you are missing. So let me pull that up and begin. Let's pull it up so you can see the kind of stuff that you're missing. Now, this is made with Serpent's Bite apple cinnamon flavored whiskey. No, not apple cinnamon, apple cider flavored whiskey, Black Button Reserve that is finished in apple brandy barrels, an egg white, cinnamon simple syrup, which I made, and it's incredibly good, and lemon juice. Watch this. Awesome. Oh, wait. So good. I'm telling you what, this is my favorite new thing. The whiskey sour is a great drink, but the cinnamon whiskey sour, the cinnamon apple whiskey sour is unbelievable. Alex wants to know what nail color I'm rocking today. I love this nail color. It's a transition gel color that when it's cold, it turns black and gold, like black with gold sparkles. And when it's warm, it turns pale gold. It's beautiful. And then sometimes it's ombre, depending on what the weather is like. So it's fun. I think I got them on Amazon. Here it is. I got them on Amazon. It's called Modalone's UV gel. Look here, this. It's this, Alex. You can get it on Amazon. All right. Jeff's here.
Hi.
Legal Vices. Here you are. If you guys are
I'm
not
here.
subscribing to Legal Vices channel, you should.
Because Legal Vices is asshole. Oh, what? Sorry, what?
How are you doing? Are you ready for snooze-inducing lawyers?
Well, now was that just the perfunctory, hello, how are you doing, or do you actually care how?
Of course I care. I love
we
you.
don't have time, Megan.
How was your function?
Europeans drink fast, heavily, and quick. The European Chamber of Commerce meeting apparently was just sit around and eat chicken wings and drink and pretend to talk about Chamber of Commerce related issues, but I'm so tired. I got 3 hours sleep last night, worked the whole day, started doing the drinks with the Euros, got home, leaving for camping in the morning, and I did that thing you should never ever do. I'll just lay down here on the bed just for 5 minutes to collect myself. And then, even though I was awake for about 25 minutes of the next hour, I literally physically could not get off the bed.
Oh, no.
And I just laid there, and it felt horrible but good at the same time.
So then I dragged you out of bed?
Oh, no, I because I had to start packing for camping, so I was doing that. Where
are you going camping?
Then I'm here. Just up the coast here, about an hour and a half up the coast.
Well, take lots of pictures because I would love to see that. Did you happen to catch my latest cocktail concoction? You got to try it. It's so good. I
just watched it.
Oh my God. Cinnamon apple whiskey sour. So fall, warm, beautiful. And of course I'm in New York and apples are in season right now. And there is nothing like a New York apple in September. They're so sweet. I actually made it like a Bloody Mary last night. I had like 6 apple slices inside my drink because I was just eating the apple soaked in the whiskey. God, is that good? What's your favorite drink these days?
Just a second. I'm preparing an old fashioned as we speak.
Oh,
excellent. It's hard to do this sitting down, isn't it?
Yes, sitting down is absolutely impossible to mix a drink. When you're standing, somehow nothing spills and everything goes where it's supposed to. But when you're sitting, it's like the elbow is too high or something. I don't know, but there's like an awkwardness to sitting.
People are you look terrible making those cocktails every day. You try it sitting down on camera.
Yeah, it's really hard.
Easy.
It's really hard.
They're pretty good for the way they turn out.
I spilled so much of that gin when I was making it the other day. I spilled it all over my tray. Do you have that gin with the butterfly pea flower? It's like blue, and then it changes color when you put lemon in it. It's incredible. It's really interesting. It has like this butterfly pea flower extract or whatever, and it makes it this beautiful color. And it not butterfly urine, it's like PEA, pea flower. Pea flower.
No, we don't have that kind of gin here.
I'm trying to figure out some good recipes to make with it because it's a really fun drink to use at the bar, and I'm training to do the bar at work. So I'm trying to come up with some new recipes, and I'm experimenting right now with the cinnamon simple syrup. But the pea flower extract in the gin is really interesting. Very interesting stuff. Wow. So how are you making your old fashioned? Do you use the brown sugar?
Yes. The only way.
That's the only way to do it.
Now my auto brightness thing is having a fit here. So I'm just gonna
I know what it is. I know what it is. You have I do. You have your check your settings. Your white balance is probably turned on.
I have like a mega super expensive DSLR camera that the auto brightness function is on, and I don't know what
I hate that. Look, I'm changing
Yeah,
mine right
yeah.
now because I just realized it was on. My auto brightness was on too, and I always turn it off. I hate that.
Yes, I just don't know. I don't know how yet. Well, I know how to turn it on and off. I just don't know what the proper f-stops and exposure settings are for my setup
Gotcha.
here. And I just need time to do it. Maybe over the long vacation I will. But no, there's a great cocktail that one of my friends made here. He was a member of the Korean national bartending team. There's another cocktail called Autumn Leaves, but he has one that he also, well, it's nagyup in Korean, which basically means like, because they have like danpung, which is the colored leaves on the trees, and once they fall on the ground, there's a different word for the leaves that are fallen on the ground. Those are the nagyup, so he calls it nice. So it's like fallen autumn leaves. It's a beautiful drink that uses a good Scotch, Benedictine, and sweet vermouth, and it tastes even more fall and Christmas Eve. Use like a nice spicy rye, so it gets a lot of those Christmas cake flavors. And you burn a little cinnamon stick in it, and you put the cinnamon stick in. Toast a couple of star anise. I know you're not a big star anise fan, but
well, I actually was looking at some recipes with drinks that had that, and I was thinking I might actually really like that in a drink scenario. I just don't like licorice in general, and star anise reminds me of that. But I think in small quantities, I could be convinced. Hey, Joe says, Vices makes a drink at the beginning of every live stream. I know, because I watch his live streams almost every day. And yes, I love watching him make drinks, and I do similar on Locals. I make a lot of pre-dinner cocktails if I'm doing my dinner stream. I made my Aunt Dorothy's favorite drink, a vodka or gin gimlet, the other day, which really brought back the memories. My grandmother and her sister-in-law used to always make a gin gimlet at holidays, and it just reminds me of my grandma so much. And that's it's actually a decent drink. I think
I'm a huge lime head, so I mean anything
me too.
Like lime and mint, anything with those two things in it, heaven if you can get them both into the same drink. The problem is bar. I mean, you work in the restaurant, the bars. Bars are in it to make money. They're not into it to make good drinks. So don't wait. If you're going to make a gimlet, use some good simple syrup and some good fresh squeezed lime.
Fresh squeezed lime, not that
don't
lime
run out and buy
shit.
that lime syrup.
No, we don't use that. Well, but see, the restaurant where I work is like a culinary experience. So they would never be caught dead using that fake lime stuff. We do have a bottle of grenadine, but that's for making kiddie cocktails. Other than that, we don't use it. We have freshly made berry simple syrups, lemon simple syrups, lime simple syrups. So
I do.
Or just fresh squeezed lime juice, fresh squeezed lemon. So yeah, it makes a big difference. I always squeeze my own fruit in order to do my drinks.
There's so many just horrific shortcuts that bars use. First of all, they're using the absolute shittiest alcohol in the entire continent. They just the cheapest they can find. They put in the well drinks, and then you want to make a mojito. Oh, they pour in their mojito sour mix.
And then we don't use mix. We don't use sour mix at all. Thank God, because I'm telling you what, that stuff is gross. Like there's nothing better than actual lime and lemon juice. When you're making a margarita, you don't need that sour mix crap. No, you don't need it. So I'm being told that today's trial, the Maya Kowalski trial, that perhaps there isn't a trial today and it's just lawyers arguing, which works out because I wasn't going to be doing this all day anyway. But what we can do is have Jeff tell us what's going on if we don't know. Because I love having a lawyer here to answer my legal questions because sometimes I don't have a freaking clue what's going on either.
We're in trouble.
Shut up. But wait, before we play that though, I'm going to play for you what I believe these lawyers sound like. This is what I hear when I hear these lawyers, and this is all I can think of. And this is how I felt yesterday while we were trying to watch them get through this trial. I'm going to play a little something for you. I swear these guys could make $1 million with a YouTube channel like this.
Do not listen to this recording whilst driving or whilst operating machinery.
I think these are the guys I listen to.
When you can safely relax and bring your full awareness to your own complete comfort.
This sounds a lot like the guy I listen to.
Yeah, Michael Seeley. He's great.
Yeah.
I like Michael Seeley. He puts you to sleep. So if you need to go to sleep at night and you can't, find Michael Seeley on YouTube, and this dude will put you to sleep. Like, he just starts talking and like you pass out. It's unbelievable. But that's exactly what these lawyers and
Nice.
tell me if I'm wrong. Let's go
dear.
over to the
'Cause
trial.
I hope not, because like I said, there's one guy that I listen to. It might be that same guy. I just have it on like auto. I have no idea who it is. It's just I push play and says how to go to sleep in 12 minutes.
Yeah,
and
then
I'm
you
gone
pass
by
out.
about 5. Yeah.
Uh-huh. Yep. Uh-huh.
Does have a nice haircut though. I'll give him that. Good going, Judge.
Which my
Little
judicial
hair island there.
Oh God, the hair
asked
island. Judge Tufty.
yesterday. So, can someone give me what you want to look at?
Here, we're gonna speed
Wouldn't it be
them
funny
up.
if he
a little.
graduated from
Very
like
short, Judge,
Tufts
but
Law
the
School or
problem
something?
is It's electronic. And so if there is something.
Oh God, it's always the
email very
technical
quickly,
problems.
Have it in 2 seconds.
Well, the problem again is my assistant is doing other things right this second.
He is so short-tempered.
Into the record.
Wow.
This judge is super short-tempered
Well,
too.
let's deal with something else while my assistant is doing other things.
Your own outline suggested maybe the motion in limine I presented about the 2015 issue and chapter 39 and the instruction he has, although it says it's false imprisonment, is really relates to the 39 matter. I suspect that those two things might. The first one probably
God,
doesn't take
this
much time
courtroom
to do those
screams
two. Then there's about
2004 classroom.
jury
I
instructions
know,
that
it's
if
so
we can-
bad.
we know are disputed, and if we can resolve
With the
those, I
IKEA
suspect
desks
we could
with the
delegate
cheap,
an
shitty
This is
plastic
that
veneer
movement.
on them.
progress on
This is part of the movement that took
Well,
all
let's-
beauty away
let's
from
do
architecture.
DIN 3411 docket
There's
identification.
lovely
jail
gray
cell.
panels on the back wall there.
Defendant J. Hatch's motion.
Sound deadening.
In limine to prevent evidence and argument concerning a claim for failure to diagnose and treat CRPS in 2015. Mr. Altenburn, your
Yes.
motion.
on
See, I
that
imagine this is what
particular
MG
claim.
Law looks like after about
The,
8 vodka tonics on a Saturday night.
All of a sudden, I
Just
dropped
kidding
that
if you
file.
ever happen to
But,
see this, MG.
We have moved in limine because of the opening argument. The opening argument begins and talks a great deal about medical treatment between 2015 and October 2016. I don't have any problem or concern with that.
This is
situation
Milhouse from The
is an evolving
Simpsons in
Yeah.
his later
Bill comes
years.
in.
He didn't talk very
And
much
Conceivably, what
yesterday.
is in Johns
Yeah.
Hopkins All Children's Hospital.
This is seriously
medical
Milhouse
records
from The
He
Simpsons.
got he got yelled at for not
6th
talking into the
October of
microphone.
2016 would inform some of the decisions they would make in that time period. But in the opening, it began to feel like he was saying that we should have diagnosed CRPS earlier than we did.
Seriously, I'll give this judge
But there-
$1,000
there was an
if he
opportunity
actually
to do that
graduated
that
from
we
Tufts
missed,
University.
Has never been alleged. And then towards the end of his opening, there was discussion that because there is a theory that CRPS can be cured if it's treated early on.
Oh wait, I forgot to tell you guys. If I freeze and I disappear, Jeff will just take over the stream. But my StreamYard has been still having problems, Jeff. I keep getting kicked out of my own stream, and I changed browsers twice, so it's
Weird.
not my browser.
That if that we
What
could
the
be
hell's
responsible, that
CRPS?
Johns Hopkins
That's
could
the
be
pain
responsible
disorder.
for
So
all of the
okay,
damages.
quick recap. She was diagnosed by Dr. Kirkpatrick with CRPS when she was 9. He's the one who took her to, he had her do ketamine treatments. The ketamine treatments appeared to be working for her. She was doing well, but then she had a relapse and it was so bad she had to be hospitalized. When Johns Hopkins found out that she was on these high infusions of ketamine, they accused her family of abusing her, even though she was under a doctor's treatment. The hospital, Johns Hopkins, claimed that she had a psychological disorder brought on by Munchausen syndrome by proxy that her mother suffered from, or factitious disorder. Then they said it was factitious disorder, which of course is the same thing. CRPS is complex regional pain syndrome, which she actually has. And Johns Hopkins said she didn't, said it was a psychological disorder. And then they kidnapped her from her family and kept her from her priest and from her religion and from her, they wouldn't let her have a rosary or a prayer book. They wouldn't let her see anyone. Oh yeah. Yesterday's testimony was insane. People from a woman from her church tried to bring the traveling Mary and a rosary and a prayer book to her, and they kicked her out of the hospital.
Why?
And she was so funny, Jeff. She was like, there was a dark force behind me. And they were like, well, what was the dark force? She goes, I don't know, but it was dark and it kicked us out. Like she was so funny because at first you're like, well, that sounds a little nuts. But then when you think about what these people did, It is so dark and so evil, and it drove her mother to suicide. So if that's not darkness, I don't know what is, because Maya's mother committed suicide when the judge ruled she couldn't even hug her child in court and was keeping her child away from her because they were falsely accusing her of abuse. So, and she really does have this pain syndrome. And this guy here is trying to argue, well, they're saying we should have known that before we knew it. But, you know, we didn't know it until we knew it. We had to rule everything else out. Well, how come other doctors knew it? How come Dr. Kirkpatrick knew it? And how come her pediatrician knew it? Where do we draw the line? When do doctors get held accountable for what they don't know is the question.
How come they won't let her have personal stuff?
Because they're evil, sick, dark people. That's why. Isn't that disgusting? It's horrible.
I just don't understand. I mean, I just don't understand. Wow,
I know.
that's kind of
I
weird.
know, but this is the kind of stories. These are the kind of stories I've been covering for 20 years, Jeff. This is not unique. Okay, CPS they are evil, and they do things maliciously to families that drive them apart, that keep them apart, and they do it for no other reason, it seems, than just being malicious. What they did to Cynthia Absug was malicious. They wouldn't even let her see her son in visitation. They took her away her supervised visitation. 60 days they kept her from him, trying to prove that she had Munchausen syndrome by proxy. Imagine a 7-year-old being torn away from his only parent for 60 days with no explanation. They wouldn't allow her to say, I love you during their visitation. She wasn't allowed to say that because it upset him.
Okay, so CPS that's not letting her have this stuff, not the hospital.
No, the hospital also. So that's what they're trying to prove here.
CPS, I understand. Hospital, all right.
And that's what the hospital is trying to say. It wasn't us. It wasn't us. It was CPS. It wasn't us. It was the court order. There was no court order that said she couldn't have religious items or religious books or meet with a priest. They wouldn't even let her meet with her lawyer by herself. No legal privilege. They gave her no attorney-client privilege. How sick is that?
Now that I know the basics of this, who's getting all the money?
It's a $200 million lawsuit against Johns Hopkins, but so far, I don't think her attorneys are doing a very good job. And this jury seems really fucking stupid. They ask questions, you know? They ask questions.
It's one of those, okay.
Mm-hmm.
Right.
And their questions have been so dumb. And their questions to me sound like they are considering that the child may have faked it, which is ridiculous because it's not in dispute that she has CRPS. So why they're asking if she needed a strap to hold her up in the wheelchair or if she needed to be balanced on a stool, I don't understand why they're asking that. That has no relevance to anything. And that's the kind of shit that they are talking about. MJ says Law and Lumber thought that they turned things around yesterday. I don't know what he saw, but I saw, well, okay, I'll tell you what. The psychologist's testimony was good for the plaintiff. She was very credible. You could tell Johns Hopkins was terrified of her testimony. She confirmed that the hospital was keeping people from Maya, and they didn't want that said. She also confirmed that there were standards of care that were not upheld, standards of care that she's never seen before, standards of care like not letting her have her religious items, keeping her from, just crazy. They didn't like that last witness for Johns Hopkins, but it was so boring yesterday that I hope to God that the jury wasn't fucking sleeping. Because
sounds like they were part of the reason people were sleeping.
Yeah. So
here
we have to try to figure out what they're arguing.
That the other two doctors did after that point in time would be after the fact of this defendant's negligence as medical professionals. And that's never been alleged, as I've laid out in the motion, not from the first complaint till now. B, they alleged in the last complaint, and maybe the one before that CRPS is a permanent reoccurring disease, not that it's something that could have been cured at some earlier point in time. And finally, had they raised claims about errors in medical standards for 2015 in their original complaint in 2018, the first thing they would have gotten would have been a motion either to dismiss or motion for summary judgment on statute of limitations, because they knew from their own doctors that they had gone to that they believed that ketamine was the solution to this problem. It was the
ketamine.
And they knew that well before.
They also, one of the lawyers calls it
not only the
oxycodone. Oxycodone.
Does not.
Oh, yeah, he does. He says
I'm not
oxycodone.
asking that that evidence not come in. I'm asking that there not be a jury instruction on the standard of care or a theory about a medical negligence claim prior to entry into the hospital as explained in the complaint in October of 2016. And
This guy's so old, I bet
the
he's been
arguments
leached.
that we should be responsible for all of
Bloodletting.
this because our
Yeah.
negligence occurred before their doctors ever saw the patient also should be excluded.
God, this looks like a sterile facility.
Yeah. I think this one's mine, isn't it? Your Honor, Tom Elliott again for the reporter. We filed a response, which is DIN 3.
Is the newspaper being sued or something?
No, I
And
don't know. I don't know what
Just
this
for
is
the
about. I'm trying to
reporter.
figure out.
the plaintiffs are not making a claim for medical malpractice based on 2015. This is, as we say in the response, this is background information. Both sides referred to it. We cite a number of places.
I think he meant for the court reporter, that he said his name for the court reporter.
Where
Okay.
the defense referred
Makes-
to
that makes
what
sense.
happened before that.
Ooh, look, avant-garde camera work.
Now, so I don't think that we're not going to ask for a line item verdict on
What the fuck is
2015.
this camera doing?
I mean, this.
All right,
this is not the
local
instructions in
AV
front of you
student
now,
who
but
is
they're
currently in the
med
courtroom
mal
with a
instruction.
camera,
If
knock it off.
Defense is still planning to blame the earlier doctors. We're going to have a discussion about the level of proof for that. I think it's not clear to us at this point if they're still planning to do that. But that would
Mr.
also, of
Elliott,
course,
let me
Is this
ask you
judge
this.
cosplaying
What am
as
I
an
supposed to
alcoholic?
do with Mr. Anderson's comments and opening statement that Johns Hopkins All Children's Hospital missed
I'm not saying, of course,
7
he's
prior
not. Wink,
opportunities
wink.
Wink,
to
wink.
diagose
Because there's no lawyers or
Your Honor,
judges
I
with
think that's
substance abuse
relevant
problems.
to
Wink,
how they
wink.
handled it when she got there.
He does look like he
Having
was up
missed
all
it.
night.
He looks less than
The
fresh.
jury
yes.
would be entitled to wonder, to infer from that, well, maybe that's why they wanted to say it wasn't.
That Dairy Queen
where is
Sunday
that
head.
covered in the pleadings? Where is that in the Eighth Amendment complaint? Can you point to me any paragraph in the Eighth Amendment complaint?
It's pronounced paragraph, I
Long
believe.
complaint. I'd have to dig in, Your Honor. but I think,
Paragraph.
well, in the medical malpractice claim, let's look at that.
I want some of that oxycodone. The oxycodone. Oxycodone.
He can't even pronounce malpractice right. Malpractice.
We have a real syllable problem or an accent problem in this trial.
With the treatment regimens.
And then 127.
27 as well.
This is like the old, was it Rankin Bass
mean,
Rudolph the Red-Nosed Reindeer things? Like all these
It is,
people
as
are
I
just
think Mr.
stuck on the
Olmsted
island
said,
of
part of the
lost
story.
toys.
That doesn't mean it's they're seeking the plaintiff.
It's the island of misfit toys.
Monetary
That's what it
relief
is.
for that, but it may explain, in their view.
This lawyer even has the same haircut as the little elf that wants to be
what
the
happened,
dentist.
Some of the reasons for things happening
well,
later.
hold on a second. 127 doesn't
emphasis.
isn't backwards looking. It
The
talks
emphasis
about
is all wrong.
Terminating
Totally
Maya
all wrong.
CRPS treatments. The October 7th.
He's Tufty, the drunken unicorn.
And then
Yeah, we call him Judge
17, you
Tufty.
said?
Just a Dairy Queen Sunday.
19.
He is hanging on
Which
to
is-
that little
which
hair
is,
island
gonna be
like it's the
incorporated,
last
right,
island in
into-
an
yeah, that's
ocean of
incorporated into
misery.
the medical malpractice count.
Right, but nothing about 19.
I bet he combs it in the
suggests any
morning.
sort
Just a little
of
comb right through that little.
culpability
Puts a little gel in
on
it.
Little
the
gel.
hospital's part concerning events occurring in 2015. The point is that, and as I'm sitting here, I thought Mr. Anderson was trying to allege that
Okay, the lawyer's in a
we're trying
different
some
courtroom.
issue
Okay, that
involving
explains why they're showing
2015
the
when
camera,
clearly we're not.
showing the monitor, showing the
The
camera.
judge does not like plaintiff's counsel, and you can just tell.
From our point of view, and the reason we put that in is the jury had.
Of course
to
not. He's
know
wearing a
the number
fucking
of
polka dot shirt.
opportunities that they had to develop the information such that in 2016, she was again seen on multiple occasions, and we allege. And so if they knew back then and put it into the records when she came back in, we're not alleging that they should have identified it immediately. Nobody did.
I think you said they missed the opportunity to diagnose CRPS 7 times.
Well, didn't they though?
Well, that's true. And most of those fall in 2016. Now, we're not alleging that in 2015 that they malpracticed by coming in.
Did he have a stroke? He hasn't moved the right side of his body once yet.
I know
is warranted for background information.
The way he
I don't really
talks
understand what their motion
was
is.
eating it up.
If it's
Why is
shouldn't
Caitlyn
be,
Jenner
on
in the back
based on
of the
court's
court
prior
there?
Comments, it should be to exclude
This one right here.
the entire
Mhm.
lead up to what happened in 2016.
But I think that's what Mr. Altenburn is saying. It's your pointed comments gave the impression to this jury that we're trying something that's not contained in the pleadings. And he doesn't want that to happen. I don't want that to happen.
So if the ruling is
This judge
I
is
am
so
not
bitchy.
to address, and my experts are not addressing, so the court knows, my experts are not addressing any culpability.
Kind of weird that you'd have
for
Caitlyn
2015.
Jenner and Kelly Clarkson sitting next to
We're
each
not.
other in a random
And I do
courtroom.
not intend to raise any further, other than to point out they received information and symptoms throughout 2015, such that by the time they were approaching the October date, they had every bit of information they needed to come in, including diagnoses of CRPS, which I think is part of one of their claims is that, yeah, we did spot it. It was just one of our many that we thought. So
Where's Dr.
having
House
the
when you need
statement
him?
that they missed these opportunities does not mean at the time. It means that they had the information all along. Now, if the court wants
The
an
judge
assurance from
hates
me
these
that
guys,
in
I'm telling
closing or
you.
with my experts that I'm not arguing malpractice in 2015, you have that. What I am arguing is that when she started to have a relapse, when she began coming back in 2016, they were armed with every bit of evidence necessary so that none of this should have ever happened. And that is clearly alleged in the complaint. And that has clearly been testified to over and over again by Dr. Newberger, among others.
I don't
including
have the
Dr.
greatest
Kirkpatrick
posture in the world,
and
but the
Dr.
way this
Choker.
guy's shoulders and neck are is
So,
making my
I'm
own
not
neck
sure
hurt.
what the
I
defense
know.
wants.
He looks like he's in pain.
Motions in limine are not to be used as summary judgments, and they're not,
CRPS?
usually you don't hear about them in the middle of trial. I do not want any. I
He's like
pray the
Snoopy
court
doing his
that
vulture
we don't have any
impression.
instruction that might diminish my standing with the jury on that point. If there needs to be an order that says the plaintiffs are not going further to make any allegations or statements from which the jury may infer.
Let's set the courtroom on
prior
fire and see if that
misconduct
evacuation
in
plan above his
2015,
shoulder
not
is accurate.
misconduct, but medical negligence in 2015, then I'm not opposed to that because that's not a big part of my case. But I just simply want to make sure that I can reference the history of treatment because that is absolutely pertinent to the decisions they made in October
You
of
would think
2016.
that history of treatments, yeah, it makes every sense in the world.
Weird.
It seems like we're not very far apart on this at this point in time. So, if he's giving us his assurance, he's not really going to try.
So is plaintiff's lawyer practicing to be a ventriloquist?
I will trust you. But I do think, as you
He's
point out,
just
that
standing there
I was
talking.
left
He's
with the
not
impression
moving
that
very much
before
at all,
the
giving his
jury
lectures
was
there.
That we were trying a case beginning in 2015.
I'm telling you,
A curative instruction
no
doesn't
one
need to
has
be a
any
long instruction.
charisma in
It
this
simply
trial.
explains to the
It is
jury
a
that
charisma-free
malpractice
trial.
is a claim for
Convince me this isn't Millhouse from The Simpsons in the future.
thereafter, informed by what John Hopkins
Sounds like him, looks like him, talks like him.
records in the past as well.
Yeah,
I
it
don't have-
does.
We can work on the language of that, but I don't
It's
have
weird.
problems with that because I agree. Whatever was not
Yeah, this is
admissible
how I
was
feel,
on the
Elsie.
John Hopkins records on October 7th, 8th, and 9th is material that they probably had access
He
to.
can't, his neck hurts.
He can argue that.
He needs to go back to waiting tables. That'll fix it.
We believe that this
Fix
is
me.
something
Why would-
that can be
why would you
handled
look at someone like
with
this?
instructions at the end to make very clear, we have no
Just
doubt
try
in the ability
this.
of the
Anyway,
defense
sorry.
to use
Maybe
that
he has
instruction
some
to
sort
make
of
clear to the
thing.
jury that this case is about what happened in 2016, not about what happened in 2015. Hopefully the instruction would say, you may consider the information carried forward or words to that effect, but that's something to be decided down the road. Right now, we object to any order in limine or instruction to the court. I understand and have put on the record that neither me nor my experts are going to testify, are going to raise or testify to medical malpractice that is a breach of the duty of
Well, I
reasonable
hope
care,
you're not going to
deviation from the
testify to
accepted
anything.
standard of care
That would be
during
weird.
2015. However, they are going to testify, as they must, to lay the appropriate predicate about the course of dealings and the
That's
course
what's
of
with the
treatment
1950s
from the first that
G-men
they got
sitting
Ms.
there?
Maya. They were treating her, in fact, before
J.
she
Edgar
had been
Hoover's
announced
G-men are on the
CRPS, however
case.
you phrase it. They treated her in June of 2015. So
Barney
that's
Fife
all
back
background.
there.
But we're
Looking
not
for his
going to
next
bring in
gin
an
and
expert that
tonic.
says they began malpracticing this case in July was the first treatment, 7th of 2015.
Well,
October.
Well, because
what is up with his hair, for Christ's sake?
He's another tufty. It's a mohawk. It's a faux hawk.
It is. He's got a ridge.
Oh, that's her father, isn't it?
Mr. Anderson and his
No, he's sitting at the counsel table.
That's Kowalski. Mr. Kowalski.
Seeking to preclude.
Is he a lawyer? He's sitting at the counsel table.
Happened in the
No, but he's party to the case.
I think that certainly is.
But he should still be sitting back in the gallery, not where the lawyers are.
Where these pleadings are.
Unless he's the plaintiff.
I do not want there to be.
He's a plaintiff.
Claims argued that are outside the pleadings. We've spent a lot of time trying to identify what is and is not being tried. As far as any type of curative at this time, I'm not sure, Mr. Alton-Byrne, I need to do anything. I'll think about it, but I tend to think that when I am instructing the jury as to the specific claims, if necessary, we can put time frames in there. I think that if we need to do anything, we can probably handle it that way.
And for the record, I'm going to leave that to your discretion. I'm not going to object if that's the way you do it.
I think that's probably where I'm going with it right now. So we'll leave it. So what's next?
Well, I think counsel wants to talk about the.
I think my dad, my 88-year-old father, has that exact same blazer
in writing, but we need a
that he's had since I've been
on the
around.
testimony of Dr. Kirkpatrick and Dr. Richard.
Same tie too.
based
I
on
actually.
The court's order of. Where's the back page of the order? Order in limine.
This guy can never find his paperwork either. It's so frustrating.
Computers, look into him.
I don't even know what he's talking about, to be honest.
I'll file something.
Well, the issue is I don't know if this is a Mr. Hunter or Miss.
I'm
Crowell or
confused,
Mr.
and there are
Shapiro.
wolves chasing me.
You have Mr. Hughes here and you have Mr. Alton-Byrne, but if it's dealing with something that one of the other lawyers is dealing with, then unless you've told them that you're going to do it, then I'm not sure we should be hearing it right now.
Yes, sir. And for the record.
Yeah. So where is Maya right now?
Okay, she's not in the courtroom, but she is alive, and she's the plaintiff in this case, along with her father.
For clarification, I want to establish the bounds within which Dr. Richards can testify concerning causation, and also Dr.
If you guys don't send Megan Fox money, I'm going to call the court and tell them to talk slower.
Standard of care for the psychologists and psychiatrists at Johns Hopkins.
Seriously, this woman is doing this.
Patrick, then you change.
She ain't doing this for free. Megan doesn't deserve this.
Brewerton.
Again, you can send tips on Cash App, Rumble Rants, or Venmo. It's rolling across the bottom of your screen. I'll take them all. Hello to
Do
my
it, or the
locals.
judge is going to say, repeat that, please.
Slower. Repeat that. Do it, or I'm going to back this up and we're going to start from the beginning.
There you go.
Let's get your motion filed and we'll carve out time to.
Good morning to my locals chat, by the way. I love the ride or die folks over there. Good to see you.
Asking the wrong question.
We'll cut off your ketamine flow.
What's next?
So this is interesting. Lotus Bloom has CRPS and says ketamine has been a game changer and improved her quality of life, or his. Sorry, I don't know. They, them. I don't know, Lotus. I'm sorry. But that's good to hear.
I gave you something Friday, and there's actually a paragraph from what I did earlier that might also be an alternative. I'm happy to kind of read them aloud to you as well.
Yeah, because it's sitting in.
Cheater, you're speeding this up.
On that.
I say you slow it down. I say you slow it down to 0.5 until you get $100 in tips and chats and whatnot. Then you put it on normal.
Okay, we're slowing it down until we get
0.5. Yeah. Until you get $100.
Number 3420.
This is how it felt yesterday. This is how it felt yesterday. I swear to God. The Venmo is rolling across the bottom of the screen, guys. So is the Cash App. Not that Megan Fox on Cash App or at Megan-Fox-89 on Venmo.
Looks like it was filed 9/25.
This looks like a 2-paragraph, but what you gave
even
me,
at normal speed, it's
You're
unbearable.
too weak-willed, Megan. You're too weak-willed.
All right, we'll go to 0.75. Negative 0.75. They sound drunk.
They look it too.
Well, this is reference to DIN 3420.
If you want the torture to stop, you just have to send rants, Cash
Send
App,
money.
Venmo.
Every $50 raises it 0.25.
Looks like your first two paragraphs, not the third paragraph.
You send her 200, we should be up to like 1.5
Very,
speed.
maybe a word or two off.
Every $50 raises it 0.25.
I told you that Johns Hopkins Children's
Oh
Hospital
my God, you're killing me.
reported suspected abuse to the Department of Children and Families in good faith. And if the hospital cannot be found liable.
There have been no tips. That means we're slowing it down again. We're
There
going
you
low.
go,
We're
yeah.
going slower.
Every 2 minutes we go without a tip, we slow it down.
Children and Families filed an action against Maya Kowalski. In that action, the department obtained a court order on October 13, 2:38.
This looks like this is how he looks like he should be talking.
Department to take custody of
Not that Susan, you know how to fix it.
You
know how
can
to
make
it all
this
go
stop.
away.
You out there in the audience, you can make this go away. All you have to
For
do
only
is
$50, you can get this up to normal speed.
all you have to do. That's all you have to do. Send
For
a
just
little
pennies a
tip.
day. You can get this chat back up to normal speed.
Liable for the court's decision to enter this.
Oh my God,
order.
this is like watching paint dry.
If you wanted to, could go on.
You can do that for free. You can't do this for free. Come on, people.
DCF to
Kind of
take
entertainment.
Exactly,
It's not
Cloak
free.
and Glomer. Get on with it. Get on it.
Oh, thank God. Venmo. We got a Venmo, Jeff.
By the way, in my
How much was it?
Will call. Thanks for the $20. Says for the slow speed player.
All right, only 30 more, and we can raise it to 0.75 speed.
John Hopkins Children's
John
Hospital.
Hopkins.
Sally Struthers is starving here, folks.
No, she
Come on.
ain't.
Found legally liable.
Yeah, you think she could offer the kid a sandwich?
Abuse report.
Oh my God.
Investigation
All right, this is
of that
torturing me,
report.
unfortunately.
Well, you know, it's the price of it's the
The
grift.
price that no one wants to
The
pay.
entry of the shelter order on
30 more gets us up to 0.75.
Come on, we need to get a little bit higher,
Claims in
faster than this.
case do not include
Yeah, we hit
claims
200. We'll get up to
those
1.25, and then we'll be cooking.
and
We'll be.
I had taken
Or we
that
could be generous and say
original line
0.25 gets you you 25 gets you up
essentially
0.25.
some partial sum
It's like
I do have
0.01 per dollar.
I do have PayPal, and it's extremely embarrassing, but I'll give it to you. It's a very old address. When I used to sell jewelry a long time ago.
part
The address is sparklyfox@gmail.com.
parent agency of
There you go. You can send PayPal.
Okay, now I can contribute to that too.
Jeff is contributing so we can speed this shit up.
Which might still be preferable to me because
I can't even.
already gotten in.
Oh,
Well, for
when
example,
we hit normal, it's
yesterday,
gonna feel like they're talking in
Duncan
like
talked
faster than
about
normal.
Getting a big disc of medical records
Oh.
from DCF. Well, she got part of their investigation.
This is a Joe Biden talks right now.
The fact that they
Oh,
were
there we go, Marty. Thanks, Marty, for the Venmo. We got another 20, Jeff.
beginning to come
Another
to this
20.
jury.
All right, that
Please.
gets us up 0.25, doesn't it?
Marty says, please make it stop.
Probably a little bit
All right, yeah, we get to go up a little bit now.
confused Yet about what the story, how to put the pieces of this puzzle together. And so in some ways, I would prefer to have all
We're
three
almost
of
at
those
normal
taken care
speed,
of
folks.
now. But if the court only wants to go as far as the taking away issue.
Jeff did it.
the
Jeff
one
pushed us
that
up
I
to normal.
Presented in the filing a couple days ago.
Why don't we do this?
Woohoo! We're screaming
Why
now.
don't you put your language on here?
You
It's
want
not gonna change the
1.25, you
speed,
got to
but
pay
How come
for
you're
it.
not changing the
Be able to
speed?
help Mr.
It is,
Anderson.
I did.
If you just go up to the document projection, see if I can figure out how to do that.
I'm sorry, Megan. I'm the
I
worst
do have
guest. I haven't heard a
34.20,
fucking
so I
word
have the
they've
first
said
two
since I've
paragraphs.
been here.
I know, but you know, we're holding the chat hostage is a lot of fun, though. It's funny.
It is.
you want me to come up here, Your Honor?
This is why people
I'm
hate
just
me.
trying to figure out how to turn that on from here.
Oh, Pamela, thank you for the $10.
There's a
$10
button
more
you
dollars and we can go 1.25.
This is limited, so.
Woo.
Power is on, and
Why do they have a Penetrator 2000 there in front of
power's
the camera?
on. Well, now it's on. Now it's on. Okay.
Oh, there we go. For mental health, we got a Venmo. Mary, thank you for the next $10. We can go up to 1.25 now.
Your Honor, when you're ready,
Awesome.
I do have some comments on this.
Yeah, I'm just trying to get the
And
document
Pamela,
going.
thank you, Pamela, for the Venmo. $10 Pamela Venmo. Thank you. Love from American Dreamer.
Mr. Hughes, is there a power button?
We're 15 away from 1.5 by my calculations.
Mine's on.
That's 3 cups of Starbucks, people. Give it up.
Mike, can you oh, no, I've got it on the lectern, right?
It's up on ours. You need to turn it the other way, though.
What did Elmo do to deserve this?
That's better.
He's got the Intruder 2000 there on the stand.
There's a knob.
I continue to have trouble getting the gallery on.
Oh, Kim, I got your Venmo, Kim. Tip for normal speed. Thank you, Kim.
The gallery screen, so I usually have to turn
And here's the lawyers talking about touching Elmo's knob. Stop it.
Oh, and it just went off.
I did it on purpose because I'm trying to get the gallery ones open.
What is that
Turned on.
weird urinate on the microphone sign there in front of him?
I think it's a reminder to speak into the microphone, which no one can
The
remember to do.
original Version what Mr. Altenburn put on, I guess, gave on Friday. So do you have that sheet of paper?
PayPal says
For
no.
$100,
Somewhere, but what I've been working from,
for $100, we'll start a
34.25,
change.org position for him to shave the tuft.
So I'm trying to find the other one.
Bella, are you sure you spelled it right? There's no E in there. SPARKLYFOX@gmail.com.
It works. I sent it.
It works. Jeff sent it. You spelled it wrong.
They're
I bet
pretty
you put
close,
an E.
but What we'll do is we'll tell you what the difference is. But just as an overview, Mr. Elliott, what is your view of at least those first 2 paragraphs?
Well, Your Honor, we filed a response to the earlier version, and it is DIN 3424. And the first thing is we don't see why this is necessary to interject this in as a plaintiff's case. I mean, simply saying somebody got records, for example, from DCF hasn't told the jury. You already told them. You already told the jury in the opening that John Hopkins is not responsible or is immune for the report. The jury, I'm sure, will hear over time that the report led to a custody order. But the
Karma, we have no idea what the lawyers are
problem with
talking
this
about.
instruction,
We haven't heard a
paragraph
single
one just
word
repeats
they've
what-
said
what
because of
Warren
me.
said in somewhat different wording, the immunity. Paragraph 2 is in our view way too slanted toward
They're arguing
racist
about
toward
evidence
the
that's going to
story
come
that
in.
the hospital wants to tell.
Yeah, but whether or not
It
the
leaves out-
hospital
it leaves out
is
your admonition
immune from
in the opening
preparing a
instructions
report,
that the DCF proceedings
you're not liable
you
for
have
making
nothing
a
to do with the
review
plaintiff's
report.
claims. In other words, the plaintiff has a claim for false imprisonment. Looking at this, I mean, it talks about, in that department obtained a court order allowing the department to take custody of Maya Kowalski subject to the court's jurisdiction. I mean, are we going to put in there they didn't have permission to do it between October 7th and October 13th? I mean, we have the instruction that the alternative or the addition that Mr. Anderson referred to earlier. It's very short. I could probably figure out how to share the screen here. I'm not sure if that would help for the people who are live, though.
Your Honor, can you inquire of the clerk whether she was able to?
Her name is Beta Kowalski.
Beata is her mother. Beata. It's
Okay,
Beata.
Beata.
Brought
She's
in
Polish.
a moment ago
Okay.
was plaintiff's proposed interim instruction on false imprisonment. That's
it.
2 sentences
God, I
long.
hate this courtroom.
Yeah, that is it, Your Honor. It's
Yeah, it's really uninspiring.
it's labeled false imprisonment, but it really goes to because
Who is
it
talking?
needs to be the jury. You've already told them.
No
this,
one's
but if they're gonna
mouth
start
is moving.
reiterating things. They need to be told that they're
The
getting
guy
told
on the
again,
far
basically
right
that,
Oh.
the hospital
not
has immunity
standing
for
up.
DCF. They need to be told, and that immunity and the DCF has nothing to do with the plaintiff's claims. So that's what this was an attempt to do, to say, you're going to hear some facts and circumstances, but some that are and some that aren't relevant in making your decisions. And talking about the shelter order, which is in paragraph 2, has no effect on the plaintiff's claims I instructed you at the beginning of the trial, and that I will instruct you at the end of the trial, including the claim for false imprisonment. And we could go on and say, you know, in the videotaping and the pictures and so forth. But if they're being told, the jury being told, well, they were allowed to do this at certain points of time, they need to understand that the order did not immunize them from the plaintiff's claim that they were not allowed to do it at other times.
I mean, from a conceptual standpoint, what's the harm in telling the jury the specific date and time that the court entered the shelter order?
I can speak to that, if I may. That is that it misleads the jury into believing that that one order somehow precludes a number of the, well, already testimony that has been made in court and will be made through the experts and through the additional witnesses and through Ms. Kowalski. And I'm concerned that there are 5 orders that we're talking about here. We've got orders from October 14th, the original shelter. We've got November 11th, November 12th, January 3rd, January 14th, April 20th, that all change the scope of the custody. Now, they don't release from custody until the 13th, actually, of January. But the concern is, if we start down this road about the effect of orders,
He reminds me
and
of
only
somebody,
focus
and I
on
can't
one
think of who it
aspect of
is.
it will affect all of our causes of action, and especially our medical malpractice cause of action.
Like Mitt Romney with a
Because
spinal
the jury
fusion?
and the intentional infliction of emotional distress and negligent infliction of emotional distress,
I don't know.
because the jury will be left throughout the remainder of the testimony, and they'll just turn off to a lot of the testimony, believing the impact of that order on the causes of action is much, much greater than it actually is. The court's already been down this road and has done a yeoman's job of going through all of this to find those parts that are not subject to immunity. To come back in and raise an oblique reference to an order is going to completely, well, it'll affect every aspect of our case. And so we submitted a very basic one if the court determines it's absolutely necessary for some reason. But all of these issues, first, the court made, we all came up with, and the court read an instruction at the start that was directed towards the first 2 calls.
Collude.
We all understood that.
Collude just sent me a $95 chat. It was Bella Stella, just because your laugh is contagious. Thank you so much. I got it. It worked. I appreciate that. And Susan, you too, says, for our mental health, sent $20 for our mental health.
All right, so I have to go like to 3.0 speed.
But if we do that, we won't know what's going on.
Do you know what's going on right now?
Yeah. Okay. The big argument is that the hospital is trying to blame it all on CPS, and they're trying to say the court order stuff is the reason why they weren't able to do any of these things. And they were just following orders like Hitler's boys. And they can't do anything about that. They can't do anything about judges' orders. And it was all the judge's fault, and it was all CPS's fault. And so they're trying to keep, I guess they're trying to introduce that it was the court orders that caused all these things. And I think plaintiff's counsel is saying, no, we've already gone over this in other hearings. We know that you're immune for making the call to CPS. But if the judge has already said, if the directive is not in the order, it's fair game. There was no court order that said she couldn't have her religious items. There was no court order that said she couldn't see her priest. There is clearly no court order that says she can't meet with her attorney alone. So those sorts of things should be included. And I think that's what they're fighting about. Like, I think plaintiff's counsel is trying to say none of this court order stuff should be in, because that's not what we're fighting about. But I don't know. Am I off?
Nope.
We'll try and pay more attention.
I acknowledge that in my opening.
And he does look like Donald Rumsfeld. That's who I was thinking of.
Rumsfeld, you're right.
And the court's instruction in the manner in which I delivered my opening about what the story was and what they can consider and not consider. And so if we go in at this point, and I beg the court not to submit anything to the jury right now until you've heard more of our case, because there is a strong argument to be made here, Judge, if you'll just listen to some of our witnesses that are coming in. There's a strong argument to be made that none of this should have ever happened had Johns Hopkins diagnosed when they should have diagnosed and not diagnosed when they misdiagnosed. And so I beg the court's indulgence that if you do come up with something here, which we do not believe is appropriate, we think all of this can be taken care of at the end of the case. But if you are going to, please let us get through another week of testimony. I need to say at this point that Dr. Kirkpatrick called us late last night and he's ill.
Oh,
So
no.
he's not going to be able to testify tomorrow afternoon. So we are strongly considering putting Maya Kowalski on
Ooh.
if the court and counsel will again indulge us. She has some testimony. It is very difficult to get out of her. I know I'm off track here, but the point is, I really, really need the court to hear more of this case before we consider focusing the jury on a particular point. From their point of view, the way I was thinking of it, reading this, is they're going to go, what's all this testimony about her not seeing her mom and dad and anything? So, the judge just told us that's all out. That was the impression I got. And I think that this will have an impact on the jury far, far more than what any of us in this room are contemplating. And I'm very worried about it.
Well, let me go back to your first statement.
Yes, sir.
Of your speech there. How is it misleading to the jury to tell the jury the specific date and time of the shelter order? That I don't understand. How could that be misleading? I mean, my
This is the second time he's asked this question, and so far, plaintiff's counsel has not answered it.
I was somewhat perplexed when no one said it in opening, talking about the specific date and time. Now, perhaps that's because now you kind of changed how you're approaching this case and not talking about DCF. That's fine, but no one said it to the jury. And so what is wrong with telling the jury the specific date and time that the court took jurisdiction over Maya?
Because the term jurisdiction and the impact of a court order to your average citizen is overwhelming. And because the jury will then conclude that anything that happened after that date is really kind of irrelevant to everything. Because
Isn't that your job to explain to them that it isn't irrelevant? Isn't it your job to explain that, yes, the court ordered this thing, but the hospital still has decisions to make. They still have leeway, and here's where they went wrong, right, Jeff?
Well, yeah, and the judge, what the judge is saying seems to be judge speak for "sucks to be you."
Sucks to be you, because he's gonna rule that they can talk about the court orders, and I can't imagine why they wouldn't. I think keeping that out. I don't agree with plaintiff's counsel. I think that's silly. You have to explain to the jury how the system works.
Yeah, when you got the reports, what happened, and yes, it could be Chael Sonnen's father or Chael Sonnen himself in the future. Says Mopo.
Yeah.
if the court ordered this, why are we listening to any of this stuff? And it will diminish the impact.
The court did order it.
The court
and say we're not to talk about it now.
We're not to talk about it until we have a chance to put on our
Not to
rebuttal.
leave the room, even if you come and get
court
him.
And the jury can hear exactly what went on with the entry of those orders. And
I don't get it. He wants to wait until he puts on his whole case before they hear when the court orders were put. That I don't understand this.
also, so the jury can hear the testimony of my experts about how, and they won't, I don't know if they're going to mention the order specifically, but about the timing and the causation and the other theories of the case.
I mean,
That's all
that's
going to
your
be.
job. You can do that.
I'm willing to wager you're going to get a lot of closed body language and looking up in the air and just kind of not taking notes and looking around.
Kinda like
That's
we're all
any of the
doing.
testimony
Yeah.
that goes after that date. It presents to the jury a cutoff date, wherefore for the average person's mind, after that, well, the judge has got control. Who cares what happens?
But there are cutoff dates in the pleadings because of how you pled the case and how I've had to rule on the good faith.
High
reports of their
flux.
specific
flux.
dates and times. And what you're suggesting is we disregard those dates and times,
Shut
muddle
up, the
everything
judge
together,
doesn't
and then
like
you
you.
can't tell the
And
jury
he
what
sits
those
down.
dates and times are. I think that's very misleading to the jury.
All right.
So,
I
like
agree
I
with
said the other day, we're going to do this.
Oh
We're
gosh.
going to make a statement,
Oh boy.
and it's going to include dates and times.
Mm-hmm.
So
With that,
that's why the other day I said, we're going to do this, come up with something, and your side ignored that.
Didn't.
So that's fine. But understand that I said that.
He hates
we're
them
gonna
so
do it,
much.
and then you didn't do it.
Well, because the guy's a douche canoe.
and let me.
I don't like him already
I don't
myself.
see any date and times on this.
He's so frustrating, Jeff.
It needs to
He
take the
seems
time
so
for
incompetent.
operation. It didn't need
But from the little bit I've
time.
seen
Simply had to
here,
make a point.
if I was plaintiff, I'd kind of be upset with this guy.
I would be too. His name is Greg Anderson. He's a litigator that's been in practice in Florida for over 30 years. He owns his own firm. He apparently has this like very long, successful career, but I don't know how, because in front of a judge, he's just screwing up. He's just screwing up all over the place. They're not prepared. They can't find things. They didn't get their evidentiary hearing in before the trial started. That started the judge off immediately. The judge was so pissed off at that when he was like, we didn't get our evidence. We didn't argue about evidence yet. And the judge is like, the jury's here. What do you want me to do about that? I'm bringing them in 10 minutes. We can't get it done. So
pure 100% speculation. It could be an Elaine Bredehoff type situation, right? And you'll see this a lot in these big firms where the senior partners, the managing partners don't do anything really. You know, they do their deal. They do the rainmaking. They bring the clients in. They do some settlements. But when there's a big case, that they think is an easy case to win, they'll come in and handle it themselves to show that they're the boss, which is exactly what Elaine did, according to Chandler. It's the first time I thought she'd never been in a courtroom before, but Chandler was saying that she hadn't been there. That was her first case in court in over 20 years. Wow. It could be the same thing for this guy. He just sits back. He's the managing partner, and he says, this is a slam dunk case.
It says here that he founded the firm in 1990. He focuses his practice on corporate and commercial litigation, admiralty, and personal injury law. He has established a specialty in insurance issues involving litigation, bad faith claims, excess coverage, captive carrier, policy interpretation, and insurance coverage disputes. But when you say you're a litigator, though, doesn't that mean you are in front of a trial? It says he has tried jury trials in 9 states with a total of over 100 civil jury trials in courts. So he
that
sounds
could have been
like
20 years ago.
He sounds like a jury, like a trial attorney.
Yeah, I mean, he doesn't want to make it sound like he doesn't do anything. So I mean, if he does, I mean, he's bored over 100 civil jury trials in his life. But yeah, I mean, he just could be one of those guys who just sits around and then he rides in and like, this is an easy case, so he gets his name on it and he can say, I did this. But boy, this guy's he's not good. He's not winning me over.
Unfortunately, my StreamYard is freezing again, and now I have the wheel of death and nothing. I can't click on anything. So
we can hear you though.
The trial. Well, that's good. Is my screen frozen?
Yeah.
Not anymore. Yeah. Can you still hear me?
Perfectly.
I'll probably have to back out and come back in. So it's probably your show now, Jeff, for the next couple minutes.
Sorry.
I wish, though, that we could get some. I mean, I don't know. I just always feel really bad when somebody doesn't have a representation. Like, I'd like to see Jose Baez do this trial. Wouldn't you like to see that?
I know Joan Baez. Who's Jose Baez?
What isn't that his name? The guy who was the Casey Anthony attorney. Jose.
Okay.
Maybe I got his last name wrong.
But yeah. Don't know what his name is, but yeah,
he was fantastic. Like he cared about his client. Obviously, he cared about what was going on. This guy is just like bogged down in these details that is absolutely killing me. Killing me.
I mean, I get someone younger, more dynamic, more tech savvy, more engaging, a little more organized, and at least a little better court presentation.
Mm-hmm. All right, I'm going to back out, Jeff, and come back.
Right.
So you take over for a second, okay?
Okay. Did you leave? She left. It's my stream now. Wow. So how are we doing, everybody? I'm the captain now. Like, subscribe, do all that stuff. I do apologize for it. She's been going for an hour and 8 minutes, and I've heard about 5 words because we've just been snarky, grifting, and taking over. We'll actually pay attention here when we come back. Give her some subscribes. She needs some subscribes. What's Strawberry's eating something? What is Strawberry eating? Oh no, they're into the garbage. Hi, everybody. I hope Megan hurries and comes back because my dogs are rooting through the garbage and I need to go rectify that, but I can't leave until she comes back. It's the Jeff Show now. What is this trial about? Apparently, it's about a child being misdiagnosed with a terrible, terrible chronic illness, kidnapped, held prisoner by CPS in a hospital, Not allowed contact with anybody or anything. So yeah, well, I'm just getting up to speed on this too. American Dreamer says buy a lid. No, it's out on the veranda, and I have I didn't lock the veranda door, so they've opened it up and they're attacking the garbage. Anyway, yeah, I'm just getting up to speed on this as well. I listened to a little bit of it yesterday. Sounds pretty bad. Hi, Megan. Welcome back.
I don't know what's going on, if it's my computer or if it's StreamYard. I don't know, but I keep getting kicked out, and then I have to back out, shut down, restart, come back.
I need to go close my door and stop the dog from rooting through the garbage.
Oh, that's important.
I'll be right
Yeah, you go do that. All right. I'm going to pull the trial back up here, and hopefully I didn't lose my place, because that's going to suck having to find where we were. All right, let's see. No, of course it didn't save my place. Of course not. Because it's live. All right, hold on. I'm finding it.
How, and they won't, I don't know if they're going to mention the order specifically, but about the timing and the causation.
Okay, we're skipping
And
forward.
your side ignored that.
All right.
So that's fine. But understand that
This judge hates them so much.
Shelter order, then it should address solely the fact.
Let's back up a
solely
little bit.
The fact form of the date shelter order. Names, dates, and times from our position. It didn't need to have dates and times. It simply had to make the point that at some point the court entered an order. But if I may, Your Honor, if it's the court's position that the jury should be informed of the date shelter order, then it should address solely the fact of the false imprisonment, and it should only address, and it should also mention, I will instruct you at the end, the portions of time you may consider for false imprisonment. That is the truth of the matter, is that this really only applies, this order that we're all contemplating here, which is the shelter order. Am I correct in this? And so if the court is of the opinion, and I understand where you're coming from, Judge, we don't want to mislead the jury in any way. That's not the plaintiff's point of view. But it has to be limited enough so the plaintiff has the opportunity to present their case without the jury concluding that big deal. And so, and there are multiple orders. And so if the thing gets broader than that, then we have to get into all of the timing, because every one of these orders change the different obligations and times and who could visit and not could visit and all of that. Which I don't
And
think
that's
is
what
the
this
purpose
case
here.
is
The
about.
purpose here is to let the jury know that a shelter order was entered at this time. I understand, but it should be limited to false imprisonment, and it should have something to say, I will at the end instruct you of those periods of time, or tell them, Judge, these periods of time, there was no authority under the court's order. And that way you can inform them and the plaintiffs won't be jeopardized.
I feel that we need to tell the jury the times to which the false imprisonment is allowable and false imprisonment is not allowable.
Thank you, Judge.
I think that is fair to the jury. I think it has fidelity to your pleadings, and it's what we've been talking about for the last 2 years. So
yes, sir.
I would like an instruction that has the dates and times specifically. Now, I get, and I've indicated this in prior orders, that there are times that Johns Hopkins Children's Hospital is potentially liable for false imprisonment. I agree that there are those time periods. Let's just tell the jury what they are.
Yeah, what is the big deal? It's making this big deal out of, you're going to lose this.
Reserving on our position.
There's
on
no
whether
way
one
the
should be
judge
given
is
at
going to
all,
be
but
like, no, you
the
don't have to
plaintiffs
tell him.
Find that acceptable and would agree with the court in that type of wording. Mr. Alder.
For the record, first of all, the reason I'm asking for specific issues about taking away is that we've now had 3 lay witnesses who understandably don't understand the details of the law.
I hate dogs.
They or Johns Hopkins took Maya Kowalski away from the family. Brown did that as the 3rd one yesterday afternoon.
Well, then why didn't you object?
The jury are
Why didn't you
adult learners,
object?
and you're correct. They need to get this in segments. And that's the segment right now they need to understand is that we didn't.
They
take
keep
the
doing
child-
this. They keep doing this. They keep complaining about their witnesses after the witnesses have left the stand. They complain to the judge. The witness said this and that, and they don't know that. Why didn't you object then in the middle of the testimony. If you heard a witness say something that is irrelevant or a legal conclusion or whatever, that's your objection. But then they wait until the witnesses aren't on the stand, and then they complain to the judge like, mommy, he hit me and I need you to do something about it. Like, what is this? Do you see this happening, Jeff, in other cases? Because I'm not sure that I've seen this.
No, that's weird. That's a little weird.
It's really weird.
The court did that.
Listen to him complain about this.
That said, while she was in the custody of DCF and under the jurisdiction of the court, she was in our hospital. So even though she was in our hospital, that didn't give us immunity if we locked her in a closet. And what the three things they are alleging is that while she was in the custody of DCF, we didn't release her for a couple of days in October. We put her in our EEG room for 44 hours sometime later, and that we put her in a room to take photographs of her for a couple hours in January. Those are the three events of false imprisonment. They don't have anything to do with the custody issue. And if down the road, the jury, again, as adult learners need another segment to explain that, I am totally fine with that. And as to the visitation issues, as I've watched the last couple of days, I realize it's not something that we can just give them a one soundbite to explain. And he's probably correct. There's 4 or 5 orders.
Put on some rebuttal witnesses or whatever the hell you need to do.
Either
it's so weird. They just complain about
because there's some judicial comments in it that maybe we don't want
plaintiff's witnesses.
One way or the other, we can deal with that too down the road. But right now, I'm not prepared to tell you what I think should be told to the jury about the shelter about visitation at the moment.
Well,
Clark Kent's over there like, do I look like fat Superman to you?
He totally does look like fat Superman.
You're saying it's the concern
Oh
is
my
because
God, that's so
of
funny.
Superman's been supersizing.
Orders, the status did change at different times.
Lay off the Big Macs, Clark.
And so
visitation status.
Correct.
Right. That's correct.
And so that might be another one where we've got to identify a specific date and times.
If you felt it appropriate to give even language from
How have they not put together like a coherent timeline of events for the jury?
They haven't done anything, Jeff.
That would be opening statements.
They haven't done any of that.
With you further at a later time.
Evidence will show you that on this date they did this, this date they did this, that date they did the other thing.
And I further believe that if we simply introduce these orders, we're going to have a jury so confused they're going to be out for 3 weeks, and they're going to have a question a day.
Oh no, they're not. They'll come back really quickly and go, "We don't care. We just need the hospitals."
Especially when the evidence says, "Oops, sorry, all this was kind of by mistake. We didn't have enough evidence here." So what I would suggest, Judge, is that we get together, counsel.
So both sides are arguing they haven't had a chance to give enough evidence.
So we
and they have. It's only day 4, day 2 of testimony, or 3. No, 2 days of testimony.
The plaintiff's claims of false imprisonment. Here are the dates. In considering the plaintiff's claims of allowing visitors, here's what's allowable, or here's the parts that here's what the order said. I think that putting these in.
This is weird.
I understand the defense might be worried. Well, are we waiving anything? And for the record, I'm not. I'm taking the position that they don't need to put these in to get the information in front of the jury. And I don't argue either that in any event, putting just the orders in and then having the various witnesses interpret the orders usurps the jurisdiction and the duty of the court. I'm not telling you your duty, but you already know. I didn't mean it that way, Judge, but you know what I mean. It gives the power of interpretation to the witnesses. That's not correct. How these orders interact with the evidence is up to this court. And so I would oppose putting the orders in, and I will stipulate in the record if the defense needs anything to protect them from not putting the orders in. But I think that's the best way to handle it according to the law.
Well, there's a couple of issues that I'm hearing right this second. One issue is Mr. Altenburn's issue that plaintiff's witnesses are coming in and said the hospital took the child, which legally is incorrect. The hospital didn't do that.
Well, they did actually the first 24 hours.
That's a false imprisonment claim, which is allowed, but the physical sheltering of the child is not something that the hospital did. That's something the dependency judge found there to be probable cause for the sheltering of the child.
I understand, but again, I come back to the fact we're talking about the wording of, I think, 1 or 2 witnesses about taking the child. The simple facts are that before that order was ever entered, they had no basis for keeping that child. And therefore, they took the child and kept her away. And this was the start of all of these proceedings. They did not gain jurisdiction by making that phone call. The court,
They didn't.
the hospital did not have
You have to get a
jurisdiction,
court order
did not
for
have
that.
an order. They had no legal cause. They had no reason. Now they're going to argue, but they had no reason.
Okay,
under the law
hospital, just
to
offer
take
100
Maya
million.
away
Let's wrap
from
this
her
up right
parents
now.
to start
She
with.
said no.
If I understand the court's interest,
They
in
tried
the
to
court
settle.
order and parts of
I
this,
don't know. It wasn't
thereafter
disclosed.
Are
It probably would have
actionable
been
in
your
parts or
20,
not.
30,000,
Yeah.
maybe 100,000.
But insofar as that wording is correct.
I guess Maya turned it down, the settlement offer that they made, because she wanted this case to see the light of day. And I don't
Well,
blame
there
her.
you
She
go.
wanted them,
All
she
right.
wanted the public to know what they had done. I want a whiskey 777 send a rumble rant. Thank you so much. Says, fine, I'll donate here, but I want to know why you have the rotund juvenile acting elderly mental wonder here. Is that supposed to be you? Is that
Probably.
be nice, whiskey. Also,
It's close enough that it's probably me.
Also, how much to get Megan a shot? Well, today it's priceless because I have to go to work, so I can't start drinking. I can't start day drinking before work, or my day will be a disaster. But thank you for asking. Yeah, you can pay to get Jeff a shot, though. Jeff will take a shot for
Keep
$100.
going with this trial.
And there's no need, in my view, to correct and take away and diminish from the fact that from the first part here, they didn't have squat for legal authority to take this child.
Squat?
They
Is that a
made
term of
decision
art?
up,
Is that a
and
legal
if the
term?
court will allow, and that's why I'm hesitant to even, I'm begging the court to hear more of our case in this regard. But once the evidence comes in, I believe it's going to be very, very clear the reasons why and what they did to the child had nothing to do with whether they believed she had a victim of Munchausen by proxy or whatever it morphed into lately. And so I really think the court needs to hear more of that case. And if it needs to be set out, the specific dates that are not actionable,
Why
fine.
is he panicking that the court's not going to hear his case? We're only on day 2 of witness testimony. Bring your witnesses and put on your case. What are we doing?
I honestly have no idea, Megan. I've never seen anything like this. This is weird.
I don't know what they are doing. They didn't have their evidence together. They hadn't had an argument over what evidence was coming in. And so now we have to take a day in the middle of the trial to figure out what evidence is coming in and what he's going to be able to talk about. Don't you do this in pre-trial?
This is so strange.
I don't understand.
Still say that that's something for the end of the case. And I relied on that in my opening. So what I would propose right now is that we be given the opportunity to develop an order. Now we understand the court's position, but that we should not be obligated to backtrack on testimony that was technically true. It was true. They did not, they kept the child because they stated AMA, and we can prove, if I had my enlargement here, I'd prove that they specifically said a patient here can leave at any time. And that was in their rules, which we'll put into evidence, and that was in their protocols that we'll put into evidence. So they violated their very own internal rules by keeping that family their AMA. AMA, against medical advice, has no force of law, none. So they took Maya and took her away. What's wrong with the witnesses saying they took her? I don't.
And if there was a problem with them saying it, why didn't the defense object when they said it? Why are we arguing about it today, a day after we had witness testimony? This is absurd.
I don't think that's necessary, Your Honor. Well,
So they want jury instructions, Jeff. This is what this is about. The defense wants jury instructions to tell the jury to disregard the 2 witnesses that said the hospital took her.
Why would you do that? Why would you disregard that?
Why wouldn't you have objected if at the time, if there was truly a problem?
They said it. They said it. If you didn't object, you didn't object.
Yeah, and if I'm the judge, I'm going to go, you didn't object, so you're shit out of luck. Sit down and shut up and let's move on. What is going on here? You know what is really bothering me is that these attorneys for Johns Hopkins are throwing every dirty trick at the wall at this. They don't want to pay out the money. They do not want to admit liability, and this is just dirty shit. It's just dirty tactics by not objecting when the witness is on the stand and then complaining to mommy judge afterwards. Like what in the hell is happening here? And why is the judge allowing it? I don't get this.
Let me hear from Mr. Altenburn, then I'm going to tell you where my thoughts are.
Okay. Don't tell us where your thoughts are.
And
Tell
it
us what your
won't be-
order is.
Yeah, and it won't be with the
October
plaintiff.
and the entry of this order. I think there's going to be disputed facts about time periods and whether she could or couldn't leave the hospital. And so we do probably need to hear evidence on that. the testimony I've heard, especially like yesterday, was Beata called this woman and said they'd taken it away.
Beata.
They're talking about the shelter order,
Get her
not
name
this
right.
earlier point in time. And so as to this earlier period, I'm sure that the evidence will be developed, but it wasn't that we, again, the issue of whether we took her away from the family is not something that is being accurately explained by the questions asked and answered by the witnesses in this
Well, that's
court.
your
And we
problem
need
on cross-examination.
explanation of that. And so
Yeah.
I believe that this is an accurate.
And they crossed them yesterday, Jeff, and this did not come up. Thanks for the Venmo, Amanda. We got a $20 Venmo from Amanda with an emoji of beer glasses clinking. Thank you very much. And Cloak and Gomar paid Venmo as well that says hashtag Fox is too hot for YouTube. This is true.
That's why your name is Fox.
This is true.
Explanation of it.
Thank you very much.
This is where I think the testimony, I think there's enough testimony in now that it's important that we give the jury some context in how it should be evaluating the testimony that's coming in. Specifically, I do think we need to identify the periods of time associated with the false imprisonment claim. I also agree with Mr. Altenburn that the entry of the shelter order is not the hospital taking the child away. And I think that needs to get made clear to the jury.
That would be the state taking the child
Contrary
away.
to Mr. Anderson's argument, I don't want to have this perpetual testimony over and over and over again on an issue. I know I'm already going to tell the jury that the entry of that shelter order is not taking the child away, is not the hospital taking the child away. I already know that. I know I'm going to say that. So I am fine doing it in one combined instruction if we want to break it out into multiple instructions. I do think, although I don't think we need it tomorrow, I'm not opposed for it tomorrow, but I do think at some point we're going to have to identify for the jury the changing nature of the dependency court's orders, and again on time frames.
Okay, so what I'm following here, and I could let me know if I'm wrong, is the judge has just said, look, we understand you're saying the hospital falsely imprisoned them. And we also have CPS having an order, a removal order or whatever they just classified it as.
Mm-hmm.
So what the judge seems busy, you need to clarify from what date to what date the hospital falsely imprisoned them, and from what date the CPS removal order took place, and then took it out of the hands of the hospital and put it in CPS.
Right.
That's all he seems to be saying.
Yeah. And
why you wouldn't do that in your opening statements and go, okay, they
why wouldn't you be
removed it from the
prepared
house.
for this? Why wouldn't you be? This is the whole
This
case.
is opening statement stuff.
It's
This
the
is-
whole
We're going to
case.
submit evidence to show that on this date, the hospital, without any authority, without any court
Right.
order, without any directive from any legal source, took this child and held them against that child's will and against the parent's will from this date and until this date. And on that date, CPS issued an order to remove them. And from that point, it became CPS who's liable for the false imprisonment or the whatever you want to cat. That's opening statement stuff there.
And they didn't do that during opening statements, by the way. It was very disjointed. And it was like he didn't seem to have his story together, and it was really hard to listen to tell you the truth.
Well, it took us an hour and 30 minutes to figure out what the fuck they were trying to say.
Why
here.
didn't they argue this before opening statements happened? I mean, they're 3 days into this trial. This is day 4. And we're having to go back and say, now we need jury instructions to disregard a couple witness statements about who took what. What? This is so unorganized.
Well, they're not even disregarding the statements. They're just going to say, this is how you have to interpret the statements.
Oh, this is a good point. AP says Maya's team of lawyers was not ready for the settlement to be turned down.
Well, that's their freaking problem.
Yeah.
You prepare until you no longer have to prepare. So many of these things literally settle the morning of trial.
Yeah. Yeah, it wasn't a good opening statement.
Really?
We're all on her side, but her lawyers are just really screwing this up. And if they're frustrating the jury to any extent the way they're frustrating us, that really bothers. That's bad for the plaintiff.
They're frustrating me, and I've watched them for a little over an hour now.
Yeah.
This issue should have been a 10-minute issue.
Yeah. Yeah, but we're going on an hour. What are we? An hour now of them, and we're playing it at higher speed, Jeff. So this, oh my god,
I forgot
so
about that.
this-
Holy shit!
And so this is actually longer than that. I mean, it's true. They
dear.
don't appear to listen to the judge, and no wonder the judge hates them. I mean, it's frustrating. It's frustrating.
This would be a 5-10 minute discussion during opening statements. He says the hospital falsely imprisoned them from this date to this date. We're going to show that. And then they say, well, then they would make a rare objection during opening statements and to go for a sidebar and say, look, this is the deal we need to show. It was a CPS issue that it was out of our hands from then. We think the jury should be told this. Then the judge tells them what to do. 5-10 minute discussion. Done.
I mean, I just got the weirdest comment on YouTube. So this is not a live chat, but this is a strange question. I have a question, says Irish Hewlett. Is your channel open-minded following trial based on facts and evidence or pure emotions? It's a little passive-aggressive.
That's weird.
Of course, we follow the evidence, obviously. In this case, I'm already biased against the hospital because I've seen too many of these hospitals kidnap children, medically kidnap them, make up lies about their parents. And in this one, it's indisputable that Maya Kowalski did not have Munchausen syndrome by proxy. She was not psychologically damaged except for what the hospital and CPS did to her. So that's not in question. It's not in question that the kid was sick. It's not in question that she was mistreated by this hospital. And I want to see them pay $200 million or more, frankly.
Well, she should bring her own claim for all these assertions that she was doing it to the child.
She's dead. She killed herself, Jeff.
Oh, that's right. Holy fuck. Yeah, that's right.
So the family is bringing the
Oh my
lawsuit
God.
on her.
Yeah. Forgot about that.
Because they drove her mother to suicide. I mean, this is a horrific case. This is not a case where it's like, well, let's wait and see the evidence because maybe it didn't happen. No, it happened. It happened. And now this is all just about covering ass. That's what the hospital is trying to do. They're trying to, limit their liability. But this should have already been taken care of before this. This is excusable that this is what we're arguing about on day 4. Just saying.
Another corollary to that, which was referenced, and I agreed with Mr. Anderson the other day, and I still agree with him, is sometimes the order said X, and then there is either an interpretation by the hospital or a request to I want to call it HRS. DCF now, to DCF. That isn't part of the court order. So I don't think that portion should fall in my instruction relative to the nature of the dependency court's order.
And I
agree with Mr. Anderson.
And I think I'm not disagreeing to any great extent on that. That the shelter orders are a standard order, and the other orders, I know that there's actually evidence in this BD called to get explanation because 2 sentences seem to be inconsistent ones. So to some degree, it's going to depend upon, I'm assuming this is all coming in on intentional infliction of emotional distress, by the way. It's not an affirmative defense that I've got, but it's going to have to come in as, whether we, I don't know whether negligent.
Are we boring you, fat Superman?
Of these orders when we receive them, and there certainly is going to be some disputed evidence on that issue.
And at the end of the day, I'm going to look to the lawyers if we're going to put the orders in, or it's going to be instructional, or both. But I do trust the jury, so
I don't.
In doubt, I'm going to put the order in if y'all
juries are so dumb.
To put them in. Whether I do it with an instruction that kind of explains, I might do that.
And I provided that instruction earlier. They had all of them in it. It's a hard read. I'll put it that way. I don't know that I would want to read that to a jury if I was sitting where you were sitting.
Yeah, I hate jury instructions.
So, given my statements, Mr. Elegant, hold on a second. Given my statements.
Well, given my drunk statement is what the subtitle just said. It just said drunk statement.
Take my statements and try to fashion something, or are we sitting here doing it by committee right this second in open court?
You want something.
Well, you don't do it by committee. You're the judge. Take control of your court.
Some explanation of the false imprisonment periods in it. Is that what you want?
I want to identify dates and times. I do not want to give an impression that the entry of the shelter order immunizes the hospital from conduct, because clearly that's not what is
interesting.
The court's intent.
Okay.
So, and I think that was where Mr. Anderson was going. He didn't want
Mr. Anderson
to have a judicial gloss that the jury would then disregard evidence.
Rather than trying to do that on the fly, if Mr. Elliott has
Okay.
time, I would think this afternoon he and I can get on Zoom together and probably get very close to what you want.
That works for me.
Okay. Thank you. Now, Mr. Elliott, was there something else you wanted to say on this issue?
No, Your Honor, I think you just covered it there because you reiterated that we need something more than these two paragraphs. We need something that says, look, this doesn't affect the other claims. It doesn't affect the claims the court has found are viable to go forward for the jury to consider. So I think we need some. Let's see if we can work out.
That's a sound ruling there. That the false imprisonment goes from this point to this point, but even after that point, that doesn't mean the hospital can't be found liable for doing bad stuff after the CPS order.
Right, because what
Who's gonna do
if it's
the
not in the
process
order,
of Maya Kowalski?
then it was
Are you
their
telling us, Mr. Anderson, that
their
Kirkpatrick's not
action.
happening tomorrow, and we're having.
He just did a shot of whiskey.
Let me tell you exactly what I know. Yeah, as an officer of the court, we received a phone call. Dr. Kirkpatrick is vocal about when and how he wants to testify. But last night we received a phone call, which I was able to return this morning, in which he informed me that he has some kind of bug, as he put it. It actually sounded in the background like he did have digestive problems. Anyway,
He was
I
farting
take him at his
loudly.
word. So I asked him how long. He said he didn't think it would be good for him to come in anytime over the next couple of days. That leaves me with a big hole in my case. Maya Kowalski is a possibility to come in. Her testimony would
Can't
be
he
limited.
do it over
would be
Zoom?
limited to really the period that she was in the hospital and those events. And frankly, the reason, Judge, is that right now the jury has not gotten the big picture at all. They think this case is about a statue and not being able to pray. And so what we wanted to do was to put her in for a given period. The alternative is this: if the court does not need to all go at once, we'll hold her out and we can play depositions and maybe find one live witness for the afternoon. We have Dr. Chopra. He may take it into the afternoon.
Dr. Chopra,
that's all I know.
Deepak.
Let me throw this out. And Mr. Hughes, I don't know if your
Plaintiff's
other
witnesses
folks
keep
are
getting sick.
listening
This
to
is
No.
the second one.
Well, hang on here a second. I was kind of weirded out by the first thing he said. This doctor was adamant about the time and manner he wanted to testify. That's weird.
I don't know.
I must testify on this date, in this order, in this manner.
I am a little concerned about the Kirkpatrick, the doctor he's talking about, because a lot of this case is going to revolve on what the jury thinks of this guy's testimony and whether he's a quack or not. Because if he comes off as being a quack, he's the guy that did the high ketamine infusions. If he comes off as a quack, it could be over for the plaintiff, whether or not she, improved with the treatments or not. And already it's like, wait a minute, why is this guy so picky about how he testifies? And why can't he testify if he's sick? Why can't he testify on Zoom then? Can we just call him in on Zoom?
Yeah, why can't they delay a couple days? I mean, if he
Yeah.
really is an expert, it shouldn't make any difference.
No.
Like the Koreans have a saying that says it's the poor calligrapher that's choosy about his brushes.
Yeah. So that is my one concern too, is this doctor, who I thought her pediatrician did really well on the stand yesterday. I thought he seemed very credible and trustworthy, and I thought he did a good job.
Lotus Bloom says Dr. Chopra is an amazing CRPS specialist. Cool.
Good. Was he a treating specialist in this case? Did he actually see her, or is he somebody they hired? I wonder. I don't know.
But I was going to talk about our schedule for next week. Friday afternoon, which I guess is October 6th. And I think that's one of the days that we previously talked about, which was a maybe. The afternoon, we're not going to be able to have court. We can do court in the morning. Because we seated a jury faster than I anticipated, I feel like we're ahead of our schedule right this second. Right. So I was going to suggest
take a day off
and get the lawyer's view about, if we take a half day on Friday, do you want to take a half day sometime else during that week? Or do you want to just take all of Friday off? Or do you want to leave at 4:00 on Monday through Thursday? Or now, if we've got an issue with Dr. Kirkpatrick, if your other doctor, and I forgot, who do you have else coming in?
Chopra is coming tomorrow from Boston.
In the morning?
Yeah, I hope. He's supposed to fly in this afternoon.
Okay. So assuming that he goes in the morning, do you want to take the afternoon off and then just not take a second half day next week? Or what are your thoughts as
Even
far
his
as
questions are fucking
how to
confusing.
proceed?
I know.
Let me be frank, Judge. We have to fly in a lot of people. And because of that, and because schedules constantly change, we could use a day off now and then to prep and to get these people in. So that
There's a damn mosquito in here.
Efficiently and without a lot of wasted time with exhibits and so forth. So taking off at 4 o'clock on the days we're here doesn't help the plaintiff that much in terms of, because frankly, I'm pretty burnt by the end of one of these days. It's hard to stay up late and adequately prepare witnesses. So,
oh my God, don't say that, you moron.
I believe that we're way ahead
I'm
of the
doing a shitty
schedule.
case and I'm so tired.
That's all I'll say.
I'm certain we would rather have all day on Friday than to have bits and pieces as well.
Yeah, but if we do all day Friday, then that means effectively we've got Thursday, Friday, Monday, Tuesday, Wednesday, Thursday without a break.
That's right.
We prefer a half a day on Friday and a day sometime next week. Actually, when we first started talking about this before it morphed into 8 weeks, the court was contemplating taking Fridays off.
8 weeks?
I don't know that we're that far.
Holy shit.
Keeping count better than us, Judge.
Is this truly an 8-week trial?
From the plaintiff's point of view, in our
That's what you
case,
just said. It
this
morphed
trial
into an
would be a
8-week
lot
trial.
smoother if we had at least a half day and perhaps a
Good
day,
luck, Megan.
during the week.
Well, I'm not doing this 8 hours a day
So
for 8
why
weeks.
don't
No, we'll do
you
highlights.
get with Mr. Hunter and kind of get an idea as to what you want to do about next week. You know, I feel, and I think this is kind of one of the things I said earlier, is when you have a really long trial, I mean, this is a marathon, it's not a sprint, and I want the lawyers to be able to do what they need to do outside of court. And I recognize that there's a lot of work that has to be done outside of court. So I am fine if we take 2 half days next week, if you want to make it a full day on Friday, but it just seems like that's a lot of court days between now and then, when we've got a little bit of time that we could allow for a little bit of flexibility.
To be clear, I think Mr. Anderson was maybe talking about half a day this coming Friday, but that's not what you're talking about.
I was talking about next Friday, October 6th.
Yeah.
We prefer a full day off. That's better for us in terms of getting people in and having the time to coordinate the witnesses with the exhibits and figure out.
Boris Karloff here needs to stop looking around like he wants to catch flies with his tongue.
Perhaps with the court. Extra time is always good. We prefer to have a half a day.
Prefer to have
this
half a
week,
day, Your
only
Honor.
for scheduling purposes, to allow us to figure out. I prefer not to put on Maya Kowalski this week. I think it would be better for our case if we did, but I think it's going to be a long process and it's highly emotional. So I have a bit
So
of a
what about this? And Mr. Hughes, I don't know if you've been able to get a hold of them. But what
Why
about
wouldn't he end with
assuming
her
Chopra
testimony?
Yeah,
claim
that's what he should do.
arrives on time that we do Dr. Chopra
Especially if it's
tomorrow,
highly emotional.
and then
Yeah,
we can spend the
he has
afternoon
no plan.
hashing out whatever Mr. Altenberg and Mr. Elegant resolved
There is no
tonight on
plan
this
here, Jeff.
instruction. And so you would
They're
basically
just
have a
flying
half
by
day
the
of
seat of their pants.
testimony tomorrow, full day on
No
Friday.
strategy, none.
And then we'll just,
No timeline, no timing, no strategy, no witness order.
Schedule will be here first thing in the morning. She won't be a long witness. So that's just a heads up that we prefer.
I mean, Jeff, am I wrong? But when you're putting
No.
on when you're litigating a case, it is telling a story. It's setting a stage. You must have it. It's a dance. You must have it choreographed from beginning to end.
Mhm.
The perfect example is Johnny Depp's attorneys in the Depp v. Heard trial. I mean, that was a perfectly choreographed dance. And they had their witnesses lined up in exactly the right order. They had what they wanted. They did at exactly the right time. I know Camille Vasquez and Ben Chu have talked about it. They've talked about the strategy involved and how much time they spent strategizing on what order they were going to do things. This is he just showed up for this and like he doesn't have anything, nothing's planned. Well, it would be better for my case if I did that. And why is he telling the defense what would be better for his case? Shut the hell up, man.
Yeah. Well, let's just look at this in terms of dollars. Now, if this was just like a random, public defender misdemeanor criminal deal, I can see not being really prepared for trial because you've got 20 cases to do that day. This guy clearly did whatever he was accused of. Let's just do our best and throw a big Hail Mary and hope the judge comes down on our side. But this is a $200 million case. Assuming they're on a standard retainer for 1/3 of the recovery, these lawyers stand to get $70 million from this.
Yeah, and they knew it was going to be televised, and they look like bumbling morons, and I don't understand how they
and
can
again,
be so unprepared.
I don't know what their fee agreement is, but 1/3 of recovery is a standard tort claim thing like this. So assuming they could potentially get up to $70 million, freaking act like it. You should be running scenarios. You should be having all these jury experts coming in. You should be running mock trials. You should be putting your witnesses through the ringer just to make sure they're prepared. You should have the latest. Both of these guys are using freaking yellow pad legal pads. You should be computered up the ass. You should have tech there. You should be doing all of this.
They're just not prepped, and it's just weird.
And then Dr. Chopra. She won't take long.
That's fine. And if we have to, finish him up an hour after lunch, I mean, the idea is to give you a little bit of time.
Cut your hair,
I'm
you
just thinking that
freaking
this
weirdo.
might, because of the Dr. Kirkpatrick sickness. And I will tell you, and I'll tell us again, I think since there's a lot of people in this courtroom and a lot of people out and about, that if someone's sick and if we can rotate their time to a little bit, I think everyone would prefer a person who's not feeling well not come in.
Yes, Judge, we agree 100%.
The worst thing that's going to happen to us is if you all got sick or the jury got sick, then
He
we're
shits himself on the stand.
in serious time issues then.
I disagree.
Just so I'm clear, because we're going back and forth. The plan for tomorrow is Chopra
And it's Rachel.
Rachel
Rachel,
the assistant. Okay. It works.
How long do you estimate that Chopra will take?
Ginger with the soul. Jeff, am I wrong? No.
Obviously, you cannot-
Well-trained man.
Directly in an hour and a half, maybe a little less, but
He knows it's a trap.
If there's a lot of discussion, it could take 2 hours, and then that would give you an hour and a half to cross.
That would hopefully allow Mr. Elliott and I to address.
Apparently
39,
not.
Maybe a couple of things that I don't think we're going to really reach today. I might take a couple of low-hanging fruits, and I would like to try to resolve what the instruction on intentional infliction of emotional distress for suicide looks like sooner than later. But I don't know that we're really going to have time to do that the way things are going this morning. So
There's a problem for tomorrow, but that's all.
Well, I mean, I
This is
definitely
weird.
want the instruction on false imprisonment and your issue. I really want it resolved tomorrow, so conceivably it'll be given on Friday to the jury.
I think we can do that, Your Honor. I thought we were going to try to address the intentional infliction suicide instruction, and which I think we're close on. With the court need to make one call, and then the instruction on punitive damages. I'm ready to talk about those if there's time, but if there's not,
I've got the time. Do you all want to do it right now?
I'm happy to do those two. There on a parent agency, there was a really minor issue as well. We might be able to get all that done.
So, what number am I looking at? What din am I looking at this point?
We've got witnesses to prep. May we leave this in the capable hands, Mr. Elliott?
It's fine with me.
Thank you.
Your Honor, 3425 is our memo on giving the standard punitive damage instruction.
I can't believe they're doing jury
It's in sort of
instructions
further
now.
response to a more
Well, that's what I was being confused about a couple of minutes ago.
what you call it, multiple
Because don't
issue
they
memo
usually do
defense
jury
filed
instructions when they're all finished with
And
the
I think
case?
Yeah.
The defense argument
There's
was,
going to be
well, you
other
didn't
things
plead
that come
certain
up.
things, so
One
you
side
can't have
submits
instruction.
one, the other side submits one. The judge goes,
And actually,
all right, I think this is what it should be. What do y'all
because
think?
We point out the plaintiff's 8th amended complaint on paragraph 26. That's
Well, perhaps, Mr. Elliott, what will be helpful is if I hear what Mr. Altenburn's concern is, and then we'll get to your response.
Okay.
Is that doable? So
The judge
Mr.
doesn't
Altenburn,
seem to be on top of this
what
at
din
all
number do you
either.
want me to go to at this point?
The actual instruction that we proposed is in 3397.
3397.
And I think the
I
legal
feel
arguments
like this is a waste of time because in a few days, there's going to be more jury instructions that they need to add. So why are we doing it now when we have 7 more weeks of trial ahead? This is so bizarre. Trial and jury instructions usually come as the very last thing you do before the jury goes out.
Well, I mean, a lot of cases, like we saw it in, I believe the Johnny Depp trial did it that way. Other trials would do, well, they'll put Fridays off just for motions. They'll do Monday through Thursday trial, and then Fridays will be motion and shit like this day.
How strange
They
is it?
want to have the
Get
instruction
this.
based on the standard language.
I'm just going to mute them for a second. You guys can read the subtitles if you want because it's just a bunch of bullshit. But what? Get this. This trial just started last week on, I think it was a Thursday, right? There was a Thursday, then Friday, then no court on Monday. They came back on Tuesday for the first day of witness testimony. And now already by Wednesday, they're doing this. They're taking a day off. They've literally had no time at all. Like they haven't, like they stopped the momentum of the case to do this.
Yeah, it's I mean, it's weird. That's what I'm saying. It's like Friday motion day is not an uncommon thing, especially in these long trials. Like things come up during the week, you save it for Friday, you go through all of it on Friday. The jury's there Monday through Thursday. You don't go, okay, don't come this day, come one day, don't come the next day. It looks stupid, and especially in the middle of the prosecution. I mean, in the middle of the plaintiff's case.
Mm-hmm.
We're not going to be like, are these guys R-worded? Why are we doing this? And they're going to hate the plaintiff for this.
Yeah, I feel like the jury is probably confused as well. Like, where is the jury today? Did they keep them home today because they were doing this? And so now they've taken a day off. It breaks up the momentum of the trial. It makes total sense to save Fridays for hearing motions, for these mid-trial motions. But
it's so weird. Just like, go, all right, never mind. Let's just take a Wednesday and do this.
It's so weird. It's so
especially when you're talking about taking a half day on Friday the next week or taking the next Friday.
I know, like, these people are all on the jury. They all have jobs and lives to get back to, and they're supposed to take 8 weeks of their life to do this. And then there's a bunch of days off in between. That's crazy. Stina says, if I was a juror, I'd be so irritated over the schedule already. Yeah, me too. Me too. Like, their lives are on hold right now for 8 weeks.
I can't. The father there in the back, I'd be pissed.
I'd be pissed too. I don't understand how they must be feeling what we're feeling. I mean, there's a lot of frustration on how the judge is siding with the hospital, and it appears that the judge is siding with them because they did their homework and the plaintiff's counsel didn't. So it's not the judge's fault. The plaintiff's counsel doesn't have their shit together.
Well, that's kind of what he told him at the beginning when I got in, and when whatever they were talking about, it was like, well, you should have done this and you didn't do it.
That's what they told them. That's what he's been telling them since this trial started. And it's like, it's starting to get really frustrating. Like, oh my God.
And they could have up to $70 million in fees on the line here. Act like you want that 70 million, even if you don't give a shit if your client gets 200 million.
Fight like there's 70 million on the line for your new Lamborghini or whatever the hell.
I mean,
it's
even
bizarre.
after taxes and expenses, that gives you a chunk of change, man. Act like it.
All right. Well, I have lost my patience for paying attention to whatever they're arguing about today, and I'm not going to do it anymore. Because this is it's too frustrating, and I'm not going to sit here and listen to them argue about evidence and stuff. You guys, those of you who are watching it, if you want to fill me in on the highlights on what happened later, or maybe I'll listen to some of it, and try if there was anything important. But I think we've had enough. I think we've had enough. They are not going to do. I've had enough anyway. They're not going to do witness testimony today, so I guess we're off on that. We don't have to deal with it. What else is going on in the world, Jeff? Anything good?
No, it's the world. Nothing's good here.
What are you
But
covering?
you did have a very, very good show with Steve Gosney.
Oh, that was fun. That was fun.
Very
Did you
nice.
guys catch that? If you didn't, you can go back and watch the replay on Rumble. We did a show about what Catholicism means to us, and we answered a lot of questions about Catholicism and talked about history and a lot of things, architecture. It was a really good conversation. We had a fun time.
Yeah, that's when I had to leave and go to work, is when you were talking about the sunburst roof on Notre Dame. That's when I had to leave.
Those windows are so amazing. There's a wonderful book. Is it on my desk? No, I think it's on my bedside table.
Yeah,
but
you mentioned that.
I have this book about the Catholic architecture, and it is so interesting. I've not read the entire thing. It's just a small book, but it's basically about the symbolism of the windows and what the rosettes mean and what how the buildings are built, and it's just so cool. I highly recommend reading about that. There's just so much in there. But yeah, we there's just so much going on in the world, and I'm just really glad that I'm not focused on all the darkness all the time lately, Jeff, because going back to work at the restaurant has been like the best thing for me ever, because my entire outlook on life is so much more positive now because I don't spend any time watching.
Doesn't sound like it when you talk about Tales from the Restaurant. It sounds like a pretty negative.
I have so much fun. I have so much fun. It's not even funny. The Karens are crazy, but there's also like really amazing people too. My last episode was about the really positive experiences that I've had with customers, which have been awesome, like totally awesome. I got this one lady. She was so cute. She reminded me of my mom. And she has like arthritic hands, and she wanted a different wine glass because she was worried she was going to knock it over. And I felt so bad. I was like, of course I'll get you a stemless glass, and then I was trying to help her, and I was giving her tips about arthritis because my mom has it real bad. And by the time she was done, she waited until like all her party had left, and she gave me this big hug. She was like, I just wanted to hug you and tell you how sweet you were to me and how much I enjoyed being here. She gave me like 2 big mom hugs before she left.
Oh, wow.
And I just thought that was so sweet. And it's funny because you find out that as a server, a lot of people complain about serving because dealing with the public is really tough. But when it's good, it's really good. And like when you can help people and do something kind for someone or do something that makes somebody happy, it's really uplifting and fabulous to have connections with strangers. And that's been happening a lot lately. And it's fun. I met alternative me. I met me in an alternative timeline. The timelines are shifting. That was another thing that happened that was crazy. You need to go on Locals for that. meganfox.locals.com. The last Tales from the
I missed the
Restaurant.
last one.
Watch the last one. There was a ton of positive stuff in that one. And I mean, I love telling the horror stories, but truly there's so much more good than there is bad. And I love it. I love it. I'm having fun.
That's good.
Yeah.
And if it's helping physically too, that's good.
Can you believe it? I'm totally out of pain. I'm not waking up in the middle of the night in pain anymore. I'm not having any pain at all. When I sit for too long, so like yesterday, I was starting to have twinging and like, oh no, now I need to go stretch and stuff. But I'm going back to work this afternoon, so I'm excited. I'm excited to go and get my exercise in. It's amazing how much better I feel moving. The spine likes to be in motion, so keep it moving. If you're having, any kind of pinched nerve issues, move your spine. Move.
Oh, cool.
Yeah. So what's up for you now? When are we coming back with Johnny Depp sidebars?
Probably. That's a good question. Maybe Wednesday of next week. Because
can you do Tuesday? Because I'm off on Tuesdays. Why can't you do Tuesday?
Well, now your Tuesday is not my Tuesday, so let me.
Oh right.
Let me look at ye olde calendar here, because I'm leaving in about 10 hours to go camping.
Oh, you're going camping.
Several days.
Right.
Korea just has like this greatest confluence of weekends and 2 holidays ever. I've got a 6-day holiday coming up.
Well, that's fun. You're going to have some good time off then.
Because the Korean Thanksgiving holiday, Chuseok, starts tomorrow, and it's a 3-day holiday. Because that's like literally where everybody goes and visit. It's like everybody's on the move.
Fun.
I figure like 75% of the country moves because everybody's supposed to go to like the oldest surviving brother or male member of the family's house and do all of the Thanksgiving rituals and things. So everybody's on the move. So it takes 3 days. It's a 3-day holiday. So it's Thursday and Friday and Saturday. Because it's a Saturday, they give you the makeup day on Monday. So that gives you Thursday, Friday, the weekend, then Monday, and Tuesday is a different holiday. So it's just back-to-back 2 holidays in a weekend comes together for a 6-day holiday. So I'm loving that. I'm going to go camping till Sunday. Monday is International Wrongful Conviction Day.
Ooh.
So Monday evening, Solomon Anderson, me.
Solomon Anderson, yeah. I thought you were doing that. Yes.
It'll be me, Solomon Anderson, Chandler Remington, and Nick Rekieta will be doing a wrongful conviction day thing on Tuesday evening U.S. time. So that'll be my Wednesday morning. Then Wednesday evening, I will be Wednesday morning. So if I do, okay, wait a minute, that'll be my. I hate time zones. Okay, that'll be Tuesday. So Tuesday evening, I don't have anything planned. So my Tuesday evening will be your Tuesday morning. I think we can do it on Tuesday.
Okay, well, if you can do it on Tuesday, I'll be here. I mean, I can usually do Wednesday morning too because I don't usually go into work until afternoon. But but you never know. They might call me in, and then I can't be there. So
Yeah. So Tuesday evening U.S. time will be International Wrongful Conviction stream, talking about Zachariah Anderson's case. Wednesday morning U.S. time. I'm sorry. Tuesday morning U.S. time will be. Oh my God, I'm the worst, aren't I? Monday evening. Monday evening U.S. time is wrongful conviction. I mean, this is what happens when you literally live 12 hours different. It's 13. Korea is 13 hours ahead of Eastern time. So right now it's 1:15 a.m. Thursday morning for me.
Jeez,
So,
thanks for staying up with me. I appreciate it.
That's where we go. All right, let me try this one more time. Now that
Okay,
everybody's
here we go.
This is why we hate this loser. Monday evening U.S. time will be the International Wrongful Conviction Day stream with Solomon Anderson, Nick Rekieta, Chandler Remington, and myself. Tuesday morning U.S. time, we can do a Johnny Depp trial.
Don't worry.
Shut up, Jenna, and pay attention.
He's going to put it on
There we go.
the schedule. So it's going to be on the channel. It'll say what time, that he'll put the live streams out there ahead of time, like he always does.
Yeah,
so
Monday evening U.S. stream, Tuesday morning Johnny Depp stream, and possibly a Wednesday morning stream as well, but we'll see. So that we can do Depp on Tuesday.
Cool, because I need something to do while I'm waiting for this this trial to get some time into it, so I don't have to watch it on normal speed.
Jenna says, I was paying attention, Jeff.
Oh, the
Extra
chat wants
shut
to
up,
know,
yeah.
are you taking the doggies camping?
Oh, absolutely. That's just me and the dogs. We're just heading out. I do it every Thanksgiving holiday.
Do you do tent camping? Is this
of
in
course,
a tent?
yeah.
Oh, it's not like a cabin. I do bougie camping. I do glamping. I like either RVs or cabin camping. I'm not big into sleeping on the ground. I don't like it.
Well, I do bring an air mattress.
Well, the only 2 times I've ever slept in a tent, I woke up in a puddle of water. So no.
I do have a queen size inflatable air mattress.
Well, that's nice.
I mean, it's like a mattress sized mattress.
Well, take lots of pictures, because I'd like to see the Legal Vices vacation stream after. Do we get to?
Yeah, we just go full on nature. For those of you that saw the last stream, we did how to cook a steak like a man from the campground. Just threw a 2.5 pound tomahawk steak on the open fire with salt and pepper and ate it.
I didn't get to go camping this season, and I really like it. And don't tell me it's not camping if it's not in a tent. That's ridiculous. RV camping is still camping. I still cook outside. I cook on a camp stove. I have open fires. I just don't like sleeping on the ground. I really don't like sleeping on the ground. I like having something a little sturdier over my head. And my husband and I rented a pop-up camper when we went to Maine for our anniversary a couple years ago. And we traveled through Vermont, New Hampshire, and Maine, and it was so awesome. And this little pop-up that we had, it was just so tiny and perfect for both of us. The pop-up part was the mattress part. That's where the mattress goes. And then it just had like a tiny little sink. It wasn't like a real kitchen or anything, and like a bathroom and a place to sleep and a couch. That's it. And you spend most of your time outside. It's still camping. You just have some place to sleep that isn't, you're not going to get a tree falling on you or something in the middle of the night.
Whatever takes you through your day, Megan. You just think it whatever you want.
I want one. I want an RV. I want one so bad, but I can't afford one. I need to do a stream, like some kind of stream for fundraising for my RV, because I really want to go camping. And now Mr. Fox says we can't rent them anymore because what we've spent on renting RVs, we could have bought one already. So now I just have to wait till I can pay for one, which sucks, because now I have 12
then you got to
years.
find a place to park it,
I've got 12 years of college to pay for starting next year. Consecutive years, 12 consecutive years of college, because my kids are all 4 years apart. So as soon as one is graduating, the next one is starting. Yeah.
Family planning goes a long way. Too late now.
Yeah, it's a little late for that now, Jeff. Thanks for that. Yeah. All right, guys. I don't know what the schedule is going to be tomorrow. I'll probably come back in the morning for a little bit to do some of this trial if they bring witnesses back, because I don't want to listen to them argue about this evidentiary shit for the rest of my life. So we'll see what happens tomorrow. Please pay attention on meganfox.locals.com. That's where you're going to find the notifications. That's where we're doing all the fun stuff. You don't have to pay to follow me there. You can do it for free. And if you want to pay, use promo code Maya, MAYA, for a discount. You'll get a free month. You can give it a trial if you want and see what you think about locals before you commit. And that's fine with me. We're having a great time over there. I'm going to be doing a cooking stream soon. Jeff, you should join me for one of those. They're fun. We're going to make a fall chili with my friend Eric, who's a chef. He's going to walk us through a fall chili recipe. So if you ever want to join me for one of those on locals, I would love it.
Yum. Sure.
Yeah. Cool. All right, guys, you have a terrific rest of your day. And we have been sitting here for a long time. So I'm going to leave you with a Nick Rekieta fat shaming. And you're going to get up and do your squats. Get your blood moving, get your blood pumping. And remember, stop huffing butter.
You impose fatness on you. You did it by going, oh, I want the butter on the popcorn. Oh, I want the butter on the ice cream. Oh, I want the butter on the sandwich. Oh, I want the butter on the salad. Stop eating butter. Can you just get up, walk 1 mile? Do squat! Walk farther. And if you can't walk, crawl, roll, get dragged by a goddamn forklift. Whatever is wrong with you, just move. Ever. Get off the chair. Get off the couch. No one is coming to service you while you sink into that furniture, while you become one with the pleather your poor ass got on that Walmart couch. Can you try not floating into sadness? Stop eating, stop drinking, start walking, start doing anything that you haven't been doing, you fat piece of shit!